Ladies and gentlemen, dear colleagues and friends, welcome to this webinar on COVID-19 vaccinations and EU law. Thank you very much to all of you, and especially to those participating as speakers in our session today, for joining us at this very complicated time of the year. This is the third webinar of the EU Live's webinar series, and it will be the last one before a summer break that we all need after precisely more than 1 year of COVID pandemic and COVID law. This webinar has been organized jointly by EU Live and by the LexAtlas COVID-19 project. We could not dream of a best company for organizing this event, and for this I would like to publicly thank the co-directors of the project, Professors Jeff King and Octavio Ferraz, for their efforts in the organization of this webinar. Before explaining the technicalities of the event, I would like to invite Professor King to say some introductory words. So, Jeff, if you want.
I'd be delighted, and thank you, Dolores, for what you'd said, but the honor is all ours to participate in this event with you and to engage with European Union legal experts and health experts and the jurists that are speaking today. It's a real honor. So I just wanted to mention that I'm working with a network of scholars that include Dolores and several others that are speaking today on the Oxford Compendium of National Legal Responses to COVID-19. And the network that we've created together is the LexAtlas network. And all of the jurisdictions, about 60, that participate in that resource are states, except for 2. One is Hong Kong, which is a territory, and the other is the European Union. And we decided that we would have to comprehensively write the code book for producing the country reports if we were to include the EU. But so important is it that we just had to do just that. And so that report is in production, and Sabrina, who's speaking today, is one of the co-authors, I'm very happy to say. So it struck us when we did the report that the EU is of such outsized importance when looking at the efficacy and the adequacy of all of the European states' responses to COVID-19. The issues sort of say it all: borders, procurement, strategic coordination, joint decision-making. These are issues that large federal nations like the United States and Brazil and India are all also facing because they have multiple layers of governance, as we have in the EU. And we all felt in the editorial committee that the world had a lot to learn from the EU. So that's one of the reasons I look forward to today. And another is that vaccination is simply a brilliant theme for the focused discussion of the EU and the participating states. It raises all the key public law questions and issues: federalism, procurement, priority setting, vaccine passports, exceptions that are based on rights, and so on. So I think, and I'd like to congratulate Dolores for developing this theme and getting this panel together, because I think that the discussion today will be highly instructive, not only for people, working within the European Union, but for scholars and policymakers around the world. So that's all I'll say at this point.
Thank you. Now, as we have a very interesting program ahead, I will just spend 2 minutes to explain how we will be working. We will have an introductory presentation and then 2 panels addressing respectively the rights dimension and the market dimension of COVID-19 vaccines, if both dimensions can be separated at all. We will make a short break between the 2 panels of around 20 minutes, half an hour. And our intention is to have time for discussion in each of these parts of the webinar, for which we encourage you all to take notes and to pose your questions through the chat. Please do not pose your questions through the audio, because we are more than 70 people, I think, and this can be a bit messy. Another thing, timing is essential, and all speakers and moderators are strongly recommended to keep within their speaking times and to make others be within their speaking times. Please close your cameras while you're not talking or while your panel is not active. And lastly, I have to remind you all that the webinar is being recorded and that it will be made public and available on the EU Live YouTube channel. Now, I will stop here and immediately give the floor to our keynote speaker, Professor Gavin Barrett, who quite generously accepted the challenge of providing us with an overview of the different legal issues that COVID and the vaccination rollout have involved from an EU law perspective in, let's say, about 40-45 minutes, if that's possible. Gavin Barrett is a professor specializing in EU law in the Sutherland Law School, University College Dublin, where he's also the head of teaching and learning and the sometime Jan Monnet Professor of European Economic and Constitutional Law. He is the author or editor of several books on EU law. Most recently, he has co-edited the book The Future of Legal Europe, Will We Trust in It? And has written extensively on various current themes of EU law, including COVID-19, Brexit, judicial dialogue, and the economic and monetary union. We thank you very honestly for being here today, and we're looking forward to hearing you. Thank you.
Great. Thank you very much indeed, Dolores. I hope I've switched off. I've unmuted myself, so I'm not just talking to myself, which is great. I wanted to say, first of all, thank you very much to you and to Daniel for your very kind invitation, and greetings from Dublin, Ireland. It's not quite as hot as it is on the continent, but I have the good fortune to have my office up on the 3rd floor of this building, so the heat rises through it. So I might as well be over in Italy or Spain at the moment. Anyway, I'm very honored to have been asked to address this webinar. And I'm looking forward to hearing very much the expert contributions, in particular from Diletta, Dimitry, Sabrina, Mikko, and Dolores, you yourself. And I have no doubt, of course, that Jeff and Daniel will also be active and vocal chairs. Now, when Daniel asked me to deliver a keynote, he suggested that what might be useful might be for me to give an overall view of the different legal issues that COVID and the vaccine rollout have entailed from an EU law perspective, and that rather than it being a detailed analysis of each aspect, because these will be addressed in any case in later panels, it might be a more holistic view of what the vaccination strategy has meant for the EU and for EU law. So that's what this talk is going to be, a kind of a general introduction and indeed contextualization of this area. It would probably be more accurate to say that it is an introduction to some of the relevant areas, since at this stage the number of legal issues to which the pandemic has given rise has been so great that it would be impossible, I think, for me to cover more than a small fraction of them in a lecture as short as this. But anyway, here goes. So let's start with some contextualization. We may begin that by defining the territory on which we stand. And for that purpose, I'm very happy to borrow de Ruyter's definition of health law as a body of legal rules and policy provisions that mandate, incentivize, or otherwise regulate either certain actions or the refraining from certain actions in providing human health care and protecting public health. So a fairly straightforward definition there. Historically, the European Union was actually given no formal legal basis for adopting legislation, nor even express competence in the field of health law. And yet it can't be gainsaid that it has, at this point in time, adopted a very large number of rules in the health law field. So I suppose the question has to be asked how this has come to be the case and how we've come to be at this webinar discussing health law today. What has the European Union been doing in this field? How did it get into it? Now, initially, at least, it could in the first place, the European Union could in the first place rely on the creative deployment of a number of treaty articles. So it could rely on implied competence on Article 2 of the then EEC treaty, the Treaty of Rome, which spoke of promoting an accelerated raising of the standard of living. And that article was actually deemed a good enough foundation to base various programs concerning things like research, training, and information exchanges on. Hervey and de Ruyter have described this as being rather legally dubious, but as they point out, this is an example of one feature of the dynamic potential of union law. If there is no political opposition mobilized, then union action can be based on very loose and surprising interpretations of the relevant legal texts with scant judicial oversight of those interpretations. So that was one basis anyway, Article 2. Secondly, various treaty provisions relating to fundamental market freedoms, to competition law, and even to the Common Agricultural Policy were regarded as justifying interventions in the health field. Again, as Hervey and de Ruyter note, disease control measures were taken to ensure that milk sold across borders was free of bovine tuberculosis. The promotion of the free movement of workers, for example, might be relied upon to justify health benefits to them. And European level rules might be applied to the marketing of medicines and pharmaceuticals to ensure that these were safe too. And finally, Article 235 EEC, what's now Article 352 TFEU, provided reserve competence if action proved necessary to attain treaty objectives in the absence of treaty conferred powers. Now, that article was actually used as the legal basis for health measures prior to the entry into force of the Treaty of Maastricht in 1993. But the Treaty of Maastricht saw explicit competence conferred in the health field for the first time. A new article was inserted into the EC Treaty, enabling measures to be adopted in the field of public health, although excluding harmonization measures. Now, amended at Amsterdam, that article was given its present, indeed somewhat strengthened form as Article 168 by the Treaty of Lisbon. Now, since that remains the main treaty provision on health law and policy, and thus the main treaty provision governing the reaction of the European Union and its institutions to COVID-19, it's worth making some observations about Article 168 and indeed about some other relevant treaty articles. Excuse me. So the entry into force of Article 168 in 2008 was a significant development in European health law and policy. It raised the requirement on the European Union from one of supporting a high level of health protection to ensuring it. But nonetheless, Article 168 remains very conservatively worded. Union action is envisioned as complementing national policies. It is required to respect the responsibilities of the member states for the definition of their health policy and for the organization and delivery of health services and medical care. Echoing that conservatism, if we look at Article 6 of the TFEU relating to competences, that carefully describes the protection and improvement of human health, not as an area of exclusive, shared, or even coordinating competence, but rather as merely one in which the Union shall have competence to carry out actions to support, coordinate or supplement the actions of the member states. Nevertheless, the field of health policy is stronger than might at first appear to be the case. Because of the availability of single market legal bases, as Hervey and de Ruyter point out, has power to adopt binding laws that have the effect of improving health, so long as those measures remove obstacles to trade or prevent appreciable distortions of competition. Article 168 imposes limits, certainly, but these limits have their limits. The situation left by Article 168, as summarized excellently by Pernhagen and all, is that, or et al, I should say, using the Latin terminology, is that the Union does not have competence to adopt measures that have as their primary objective the harmonization of national definitions of health policy or the organization and delivery of health services and medical care, including management of health services and medical care and the allocation of resources or of national public health laws on tobacco or the abuse of alcohol. But these constraints on Union competence do not mean that harmonizing measures cannot have any impact on the protection of human health. The Union may lawfully adopt measures that have the effect of improving health, so long as those measures remove obstacles to trade or remove appreciable distortions of competition. Now, it may be noted that Article 168 TFEU itself creates admittedly very limited power to legislate. That's not the same as the power to harmonize, but it is power which is not entirely irrelevant in circumstances such as the present pandemic. So, for example, Article 168.4 stipulates that the ordinary legislative procedure may be used to adopt measures setting high standards of quality and safety for medicinal products and devices for medical use. Under Article 168.5, the ordinary legislative procedure may also be used to adopt incentive measures to protect and improve human health, and in particular to combat the major cross-border health scourges, as well as measures concerning monitoring, early warning of, and the combating of serious cross-border threats to health. Although that excludes any harmonization of the laws and regulations of the member states, it shouldn't be forgotten that the EU possesses very considerable means to incentivize action by its member states. Positive incentives, as Pernigan et al. Observe, available to the Union. Positive incentives available to the Union to offer to its member states include things like access to resources, such as Union funding, collectively held or secured equipment, human resources, pooled expertise or knowledge, administrative capacity, or information, or even the Union's geopolitical capital. Finally, under Article 168.6, the Council, on a proposal from the Commission, may also adopt recommendations for the purposes set out in the article. And that's significant in the present context, as considerable use has been made of recommendations in an effort to influence member state behaviour during the COVID crisis. Two further aspects of Article 168 are of interest. Sorry for going on about Article 168 for so long, but obviously it is key to what we're talking about today. First of all, these two further aspects are first, that Article 168.1 enshrines the obligation on the EU to mainstream health protection. It provides that a high level of human health protection shall be ensured in the definition and implementation of all Union policies and activities. That mainstreaming requirement is actually also mirrored elsewhere in the TFEU. Article 9 of the TFEU provides that in defining and implementing its policies and activities, the EU shall take into account requirements linked to a high level of protection of human health. And additionally, as if that weren't enough, if you look at the Charter of Fundamental Rights, of the European Union, Article 35 provides, inter alia, that a high level of human health protection shall be ensured in the definition and implementation of all Union policies and activities. So a fairly clear mainstreaming requirement there, hammered home by not one but three separate provisions. And then finally, Article 168.2 provides that member states shall, in liaison with the Commission, coordinate among themselves their policies and programs in the areas referred to in paragraph 1. And there, paragraph 1 includes a long list of things: improving public health, preventing physical and mental illness and diseases, obviating sources of danger, combating major health scourges, etc., etc. So that's the requirement, if you like, to coordinate between member states their policies and programs. In practice, Article 168 has actually provided the basis for successive Union public health programs, and the most recent of these is the March 2021 EU for Health program, which establishes a health program for the period of 2021 up to 2027, and lays down an annual financial envelope for that purpose of about €500 million. Overall, to quote once again Hervey and de Ruyter, the legal texts in the Treaty for Health Law and Policy look restrictive in terms of the Union's competence to create a European Health Union, but actually they are amenable if the political will is present. The Union powers to incentivize, encourage, support, coordinate and resource activities in the health field are actually quite significant in this regard. Now, it's worth expanding on that last point to point out that much of health law and policy actually consists of soft law, quasi-legal instruments which don't have any legally binding force, or whose binding force is somewhat weaker than the binding force of traditional law. But it is nonetheless quite possible for it to be of major significance, notwithstanding that. So, if we're thinking about soft law, we can think about documents, just to take a few random examples, like the 2006 Council conclusions on common values and principles in EU health systems, the recent communication from the Commission, a common path to safe and sustained reopening. These are not traditional hard law measures, but each of them seem likely to wield some influence, both in their own right and as possible harbingers of future change in the form of hard law measures. So overall, even without any treaty change that we might expect to emerge from the conference on the future of Europe, if any does actually emerge from it, even without any treaty change, the European Union is able to do quite an amount in the health policy field. One final piece in the jigsaw of treaty level rules is that the jurisprudence of the European Court of Justice indicates that there is a general principle that the protection of public health must unquestionably take precedence over economic considerations. That was seen in the Artegoden case, building on the earlier 1997 AFISH ruling. So a fairly clear identification of the protection of public health, therefore, as a general principle, and its precedence over economic considerations as a general principle of European Union law. Now, before passing from the constitutional structure of health policy and treaty rules to what the EU has actually done in the field of health law and policy, let's gather our thoughts by quoting Pernighan and his fellow authors, who have usefully summarized some of the main aspects of EU treaty rules and case law in observing that protection of human health is a general principle or value inherent in union law, which takes precedence over mere economic considerations. The union is obliged to mainstream human health in all of its policies and activities. It has residual power where no specific confidence norm is present, where necessary to achieve its objectives. And that was the basis of union health law and policy before 1993. And Pernighan et al. Also point out the textual differences between human health and public health, which appear to distinguish types of union competence, have not in practice tended to do so on closer inspection. So that, if you like, a look at the constitutional basis of activity in the health field. So moving on from that, we can ask ourselves, well, what has the European Union actually done in the field of health policy? Well, in practice, EU law has made itself relevant to the health area for at least 7 reasons. Using the taxonomy deployed in Hervey by Tamara Hervey in this regard. The first is that it has established extensive rules concerning patient mobility. Now, that's divided into rules on migrant worker access to medical treatment, plus European Court of Justice case law on the freedom of healthcare clients to receive cross-border medical services, as well as the legislation building on that case law, or even trying to moderate it, like the Patients' Rights Directive of 2011. So that's one area in which the EU has been active in the health policy field. The second is that the European Union has established rules concerning the free movement of healthcare professionals, consisting of rules on free movement of workers, service providers, and freedom of establishment of self-employed persons, as well as rules on the mutual recognition of professional qualifications, both general and sector-specific in nature, and now found in Directive 2005-36 on the recognition of professional qualifications. A third way on which EU law has become relevant to the healthcare field has been the application of applied EU free movement and competition law rules to healthcare institutions. Although each of these 3 achievements, these first 3 achievements, if you like, in the field of health law or health policy is of immense importance and perhaps not entirely irrelevant to the pandemic. They are not our main concern today when dealing with COVID. Others, however, are, because a fourth way in which EU law has become relevant consists of the application of free movement of goods law to medical products and to pharmaceuticals. And a particular feature of this EU area of law, and one which gained considerable prominence during the pandemic, has been the dual marketing authorization system, whereby medicinal products for human use are subject to a regulatory framework under a 2001 directive, and must either be authorized by the competent national authorities of the member state, or else centrally by the European Commission, acting on the advice of the EMA, the European Medicines Agency, under a procedure laid down in a 2004 regulation. That latter procedure was used in relation to the vaccines used to combat COVID-19. Now, another way in which the EU free movement of goods law attained some prominence during the pandemic was because of the objections raised by the Commission to member state bans and restrictions on exports of medicines and medical devices that featured heavily among member states' first panicked reaction to the pandemic. So, if you like, free movement of goods law has been both relevant to health policy generally and highly relevant, of course, to the European Union's reaction in the free movement to the COVID-19 pandemic. Moving on, though, from free movement of goods law, a fifth way in which EU law has become relevant in the health field concerns intellectual property law, which confers the right on inventors, of course, to exclusive rights to an invention for a period of time, and thereby encouraging both effort and investment to be put into inventions and the sharing of the benefit of the invention itself. Now, an example of relevant EU law here is Directive 98/44 on the legal protection of biotechnological inventions. This has been crucial to Commission President Ursula von der Leyen being able to vaunt the European Union as the world's top vaccine exporter, or the world's pharmacy. However, there is considerable room for controversy here as well, in that protection of intellectual property rights can be criticized as enabling major corporations to profit at the expense of developing countries that lack the resources to pay for medicines, and this during a global health emergency in which failures to vaccinate may both affect the populations of poorly resourced countries negatively, and also threaten to unleash new strains of the coronavirus into countries which have vaccinated their populations. The Commission has tended to stress both the European Union's commitment to COVAX and to point out the possibilities that exist under TRIPS as part of its answer to these criticisms, but there's probably a lot of discussion to be had on that subject. A sixth way in which the European Union, the law of the European Union has impacted in the health field has been through the adoption of public health legislation in fields such as tobacco, alcohol consumption, and food law. A recurring theme in these areas has frequently been the need for the EU to face down major corporate interests in order to achieve its goals. And that hasn't always been successful. Corporate opposition has prevailed, sometimes through intensive lobbying, which in the past has arguably resulted in, for example, considerable watering down of food information legislation. Sorry, there's somebody doing some strimming out there, so I'll just close my window to avoid the noise being too disruptive. Sorry about that. So as I said, the need to face down major corporate interests in order to achieve its goals, the EU's goals, that hasn't always been successful. Corporate opposition has prevailed sometimes through intensive lobbying, which in the past has arguably resulted in, for example, considerable watering down of food information legislation. And corporate opposition has also sometimes used litigation as a strategy, including occasionally with the active support of one or more member states, as was seen in the tobacco advertising cases, which saw one directive on tobacco advertising actually declared void by the European Union before a second was successfully adopted. Dealing with the economic power of pharmaceutical companies has been and clearly will remain an ongoing feature of coping with the COVID-19 pandemic and with any future such pandemics. A further way and final way in which EU law impacts on health law and policy is in relations with third countries. Now, under Article 168.3 TFEU, the EU and the member states are required to foster cooperation with third countries and the competent international organizations in the sphere of public health. External policy might, for example, be conducted via the common commercial policy through development cooperation or via international agreements, including in the framework of the WTO. Given the global nature of the COVID-19 pandemic, it's scarcely surprising that considerable stress has been placed by the Commission in numerous documents on this external relations aspect. Okay, so that's the, if you like, the constitutional background and, if you like, the areas in which the European Union in general has been active. Let's have a think about the pandemic more specifically. Now, Commission President Ursula von der Leyen was not wrong in her observation that the magnitude of the COVID crisis confronted the European Union with an unprecedented challenge. In responding to that challenge, Europe got off, I think most people would agree, to a fairly poor start. Initial national reactions showed a fairly distinct lack of solidarity, generating negative reactions. And indeed, I suppose it could be quite truthfully said that to a certain extent, the European Union's reaction, at least initially, consisted of recovering lost ground in that respect. And certainly in the initial stages of COVID, the reputation of the European Union clearly suffered. Gradually, however, solidarity and European cooperation materialized, and a mixture of member state and EU actions in the health and economic spheres and others besides began to be taken. One, I think, insightful and your contemporary observation made by the editors of the Common Market Law Review was that the EU was almost bound to disappoint, considering its limited competence in key areas such as public health, but also in view of the particularly high expectations that an emergency situation like a pandemic produces. Yet again, the Union is victim of the perennial expectations capabilities gap, being partly discredited for the failures of some of its own members. Now, I think one might well quibble as to whether the problem was as much capabilities as the failure by political leaders to demonstrate willingness to actually use the cooperative powers they had. But at any rate, the matters gradually changed. A major role for the EU in dealing with the pandemic was probably more or less inevitable, in that serious threats to health are inherently cross-border, and thus the solutions were always likely to be as well. Now, in addition to this, no other international organization brought the kind of resources to the problems generated by COVID-19 as did the EU. These include the active participation of 27 different states, representing 450 million inhabitants, and some of the wealthiest states in the world as well. A history of cooperation dating from the time of the Treaty of Maastricht and indeed some time before in the field of health, legal instruments ranging from hard laws to soft law instruments, the ability to enter into contractual relations, financial resources, and institutional resources as well, and including, of course, not just the traditional institutions, but a range of specialist committees, centres, agencies, steering groups, and so on, and so forth. Now, it's well known that many of the measures taken related to the economic impact of COVID. These were extensive and are important, and indeed I and others have written about them elsewhere, but they're not really the focus of this webinar, or consequently of what I have to say today. So it's health-related measures that we really want to look at. And by now, a bewildering range of EU health initiatives or EU-level initiatives in the health field has been adopted. The sheer number of and breadth of actions and measures taken by the EU, as I've said, has been bewildering, and it can be difficult to keep track of them all. But we may mention at least perhaps the major categories of action and some of what the EU has identified as the most significant recent measures adopted and in the process of being adopted. They can be grouped under four different rubrics. Measures to do with reopening generally, measures to do with therapeutics and medical support, measures to do with sectoral reopening, and measures to do with adopting a global approach to the pandemic. Now, measures to do with reopening generally, there are a wide variety of them. One of them would be a measure that will be looked at in extenso later on today, the EU Digital Green Certificate or Digital COVID Certificate. Regulation, things like the European Centre for Disease Prevention and Control Framework for reopening, the Council recommendations on the temporary restriction on non-essential travel into the EU, the Council recommendation on a coordinated approach to the restriction of free movement in response to the COVID-19 pandemic. And they're just some of the measures. There are a variety of other ones as well. A second rubric consists of measures to do with therapeutics and medical support. And measures that may be classified under this heading have included Commission joint procurement to secure access to therapeutic treatments for COVID, an area that's going to be looked at in a later session of this webinar, a common EU strategy on therapeutics, and rather more exotically, even the €12 million programme to purchase and deploy 200 ultraviolet disinfecting robots in member states that is currently being rolled out. A third heading consists of measures to do with sectoral reopening, and measures that come under this heading might include things like the 2020 guidance provided to the transport and hospitality sectors, the European Committee for Standardization document on health and safety protocols for the hospitality sector, and financial assistance provided by the Coronavirus Response Investment Initiative and REACT EU, as well as guidelines for cultural and creative sectors. And finally, rubric 4, measures to do with adopting a global approach to the pandemic. Measures that could be classified under that heading have included, or will soon include, direct financial help to states and to international partners, EU participation in COVAX, which is a global initiative to facilitate greater access to vaccines, the operation of the Union Civil Protection Mechanism, which was credited at an early stage of the crisis with contributing to the repatriation of nearly 600,000 EU citizens, and is also tasked with jobs like vaccine transport and the proposed EU vaccine sharing mechanism. So, having detailed those measures recently adopted or undertaken or on the immediate agenda, it's probably wise to paint a few broader brushstrokes, at least briefly. I wanted to say a quick word about a particular challenge, and that is the digital green certificates or digital COVID certificates. One measure that has naturally formed the focus of considerable recent attention is the EU digital COVID certificate, which recently became part of Union law with the adoption of Regulation 2021-953 on the 14th of June, and also its sister regulation 2021-954 on a framework basically with regard to third country nationals legally entitled to stay or reside in the territory of the member states and thus to travel around the European Union. Now, as I said, I don't want to say too much about this measure, as I'm conscious that it will form a major part of the subject of a later session, but just a few introductory remarks perhaps concerning it. The digital COVID certificate forms one of a number of initiatives launched by the Commission to help facilitate travel across the European Union, others being the proposed amendment of Recommendation 2020-1475 on a coordinated approach to the restriction of free movement, and other initiatives like the Reopen EU website that provides travel information on the travel and health situation in other countries. Now, the idea is that the digital COVID certificate is intended to facilitate the application of the principles of proportionality and non-discrimination regarding free movement restrictions during the pandemic. It should not be understood as facilitating or encouraging the adoption of restrictions to free movement or restrictions to other fundamental rights. Now, I know Dimitry is going to be looking at that in some detail later on, and I think he's going to be expressing some skepticism about that particular statement in paragraph 14 of the preamble. But in any case, the idea of the digital COVID certificate is that it will be digital proof that a person has either been vaccinated against COVID-19, has received a negative test result, or has recovered from COVID-19. And member states are required to accept vaccination certificates for vaccines which have received EU marketing authorization, and they are allowed to extend it to travellers who've received another vaccine granted marketing authorization by the competent authority of a member state. So in relation to the EMA authorized vaccines, though, they're required to accept vaccination certificates. National authorities are responsible for issuing the certificate, whether by test centres, health authorities, or online. The certificates are required to be issued free of charge. Member states are also required to issue certificates of recovery as well. The certificate can be stored on a mobile device, or citizens can request a paper version, and member states have agreed a common design to facilitate recognition of both. Basically, when the certificate is checked, the code is scanned, signature verified, and that can be done either via national software or apps or via European gateway. The idea is the certificate will be accepted in all member states, and that it will help ensure that restrictions currently in place can be lifted in a coordinated manner, and therefore that certificate holders should in principle be exempt from free movement restrictions, and indeed free from the imposition of additional restrictions unless these can be justified both to the Commission and to all fellow member states. Now, the certificate standardizes processes that were being adopted anyway by countries, municipalities, and even private organizations or undertakings like airlines. Now, without intending to trespass too much on this topic, a number of concerns have been expressed about the certificates, that they might lead to the infringement of the rights of those with allergies, pregnant women, and those for whom vaccination is not an option for some reason or another, whether religious or otherwise. The objection has been raised that the certificate does not in fact guarantee that the holder can't spread the virus. The non-recognition of other vaccines, such as the Russian Sputnik 5 vaccine on what seem to have been political grounds. The risk that the certificate could become a tool for mass surveillance, that even for vaccinated persons, they contain more information than mere proof on inoculation. So, for example, test results or recovery information. The fear that their use may be used to increase inequality, that they may be used to exclude persons from social or economic life, or that they expose the holder's information to the risk of data leaks or cyber attacks. In fact, many concerns from a legal perspective center on issues of privacy and data protection, discrimination and free movement, and questions have been asked as to whether they will be used primarily to facilitate more freedom of movement or surveillance on the other. Okay, I was going to say something on the procurement issue and its termination in the AstraZeneca court case, but I might leave that for the time being. I know it's being discussed later on, and I'm beginning to run out of time here, so I might move swiftly on beyond that particular issue. We can return to it in the questions if necessary. All right, there are some broader aims of the law which should yield results soon here as well, because in a recent commission, the Commission has reflected on some early lessons to be drawn from the COVID-19 pandemic. These reflections are useful, I think, for giving an indication of some of the broader directions that we can see EU health policy taking. 10 lessons learned are identified, many of which seem likely to produce consequences in the near to medium future, and in some cases, quite dramatic consequences. The first is that the shortfall in pandemic preparedness and planning has shown that there needs to be a robust global health surveillance system, according to the Commission. At European level, this is to involve the creation of a new European pandemic information gathering system built on the existing early warning system, and the plan and an upgrade of the European surveillance system. And the plan is that that should be launched already this year. A second consequence drawn by the Commission is that clear and coordinated scientific advice is needed to facilitate policy decisions. And the conclusion that is drawn from this is that a European chief epidemiologist needs to be appointed. And again, the target is that this be done by the end of 2021, by which time the chief epidemiologist should be there with the corresponding governance structure. So we can see that the idea is that things happen pretty fast. A third lesson drawn by the Commission is that preparedness and planning was not as robust, well financed, or as comprehensive as it needed to be. So a more systematic approach involving investment, reviews, audits, risk assessments was felt to be necessary. To that end, the Commission intends to prepare an annual State of Preparedness report that will be presented to the European Council and to the European Parliament. So a lot of changes coming about there, and coming about fairly quickly. A fourth lesson the Commission has drawn is that emergency tools, fast functioning and flexible temporary and exceptional measures need to stand ready to be activated. And their suggested response is the creation of a framework to allow the activation of an EU pandemic state of emergency, and plus a so-called toolbox for crisis situations. Again, action is going to take place in that fairly quickly, because a corresponding proposal will be made in 2022, so next year, for a so-called single market emergency instrument that will allow fast-track negotiations in extremely urgent situations and broader use of procurement. It will also allow EU coordination of internal and external border control measures, and a contingency plan building on the so-called green lanes framework to secure supplies in the event of traffic becoming blocked by border controls. A fifth lesson is that more coordination and fewer unilateral decisions were needed. The Commission's suggestion in this regard was the adoption of the November 2020 proposals on building a European health union. A sixth lesson was felt to be the need to increase the resilience of supply chains for critical supplies, not excluding vaccines. Now, while ad hoc solutions like a clearinghouse for medical supplies, temporary and the famous temporary export authorization mechanism were used to deal with problems this time out, a major element of the solution here is seen to be the setting up of a new Health Emergency Preparedness and Response Authority, HERA, to ensure better EU preparedness. And the idea is that this authority would actually be operational by early 2022. A seventh lesson is the need for pan-European clinical research, a permanent large-scale EU platform for multi-center clinical trials. The idea here is that a more joined-up approach between research investments and procurements would be taken under the new HERA. So it would seem that the what you might call the Oxford AstraZeneca lesson has been well learned there. And an eighth lesson is the need for continuous and increased investment by member states in healthcare systems. That seems reasonably obvious, but it's very much in member state hands. A ninth lesson is the need for a global response to pandemics and Europe's need to fit into that global architecture. That involves things like, according to the Commission, like supporting the strengthening and reform of the WHO, and the need to do more on a bilateral level. And interestingly also, I note the need to factor in geopolitical competition during pandemics. That also garnered mention as well. And finally, a 10th lesson has been the need to expand the tools for detecting and reacting to disinformation campaigns at EU level. Now, that's most of what I wanted to say today, but perhaps by way of conclusion, some tentative observations and predictions, general observations and predictions may be offered. Observation number one I would make here is that COVID-19 has changed and will continue to change the face of EU health law. Instead of largely consisting of an extension of or an addendum to single market law, EU health law is now becoming, in a process comparable to that previously undergone by EU Justice and Home Affairs law or the law of economic and monetary union, a field of EU law in its own right. Now, that process was arguably well underway anyway, enabling substantial studies of EU health law to be published by Hervey and McHale and de Ruyter. But the development of the autonomy of this area of the law is, I think, and will continue to be accelerated and enhanced by the effects of the pandemic. And I think for EU health law, the pandemic may well be compared to the banking and sovereign debt crisis of a decade earlier in the economic field, in that it has involved an existential crisis which has driven the search for ad hoc solutions invented on the hoof in order to cope with the necessities of the moment. In the health area, as in so many others, Monnet's dictum that Europe will be forged in crises and will be the sum of the solutions adopted for these crises seems to be holding good. Observation number two, the solutions that have been found to the COVID-19 crisis are in many cases temporary or ad hoc, but in several cases now, as we've seen, they're crystallizing into permanency. And indeed, that's a deliberate strategy by the Commission, which has noted the need to learn from the example of how the EU responded to the economic crisis of 2007 to 2011, turning emergency action into structural change. And the idea is that if and when the next such crisis or pandemic hits, the lesson learned on this occasion can be used again. So this is obviously a well-trodden path. It's been done in the case of economic and monetary union, I suppose it doesn't seem inaccurate to say that the manner in which the EU successfully handled the economic aspects of the COVID-19 crisis has been partly due to the fact that in the economic field, the EU already had the experience of dealing with an earlier existential crisis. So, for example, the ECB's pandemic emergency purchase program deployed to deal with the deflationary consequences of the COVID crisis was clearly rendered possible because there'd already been an ECB public sector purchase program and outright monetary transactions. OMT program had at least been proposed. Observation number 3, a phenomenon linked to the foregoing is that a process of regulatory strengthening is taking place, and that's taking various forms. So, for example, current legislative proposals will see to it that matters previously governed by decisions will henceforth be governed by regulations, which are regarded as suitable for establishing EU frameworks. Furthermore, issues that have had to be governed during the pandemic by mere ad hoc agreement. Let's take, for example, the exclusivity of the Commission negotiating and procurement rule in joint procurement procedures. They're now to be given a firmer foundation through the adaptation of the joint procurement agreement to include an exclusivity clause. And where formal regulation isn't possible, the opportunities that the EU offers for peer review may be deployed. So the EU's plans for a health union, for example, include development and implementation of national preparedness and response plans following common structures, and then reporting of those plans, an EU auditing process, and more transparency, which sounds suspiciously like the open method of coordination. Observation number 4, a further linked observation, is that as a result of the COVID-19 crisis, the EU is at present in the health area in an intense process of institution building. A number of features of this are particularly prominent. One of them is the upgrading of the European Centre for Disease Prevention and Control, with the ultimate objective of making it a real European health agency, to use the words of the Commission communication, building a European health union. And that will involve such changes as reinforcing its surveillance capacity with the aim of creating a high performance epidemiological surveillance system, enhancing its interactions with agencies like the European Food Safety Authority and the European Environment Agency, and mandating it to set up an automated system for contract tracing. A second feature of institution building is the upgrading of the European Medicines Agency. Features like the setting up of the executive steering group on shortages of medicines, the setting up of the EMA Pandemic Task Force, and the EMA's hosting of medical device expert panels, now to be made permanent and added to with a new executive steering group on medical devices. A third institutional development involves the Health Security Committee, which is a key body where member states consult with each other in liaison with the Commission concerning risks and response planning. Because of its perceived limited efficacy, it's now to have representation in its high-level working group at the level of deputy health ministers, and to be allowed to trigger common EU-level responses. And a fourth institutional innovation is the creation, not merely the upgrading, but the creation of a new authority. We've already seen the European Health Emergency Preparedness and Response Authority, HERA, which I've already looked at. I needn't say anything further on. The European Union will have changed by the time the crisis is over. While legislation of various kinds will have been adopted in the usual way, like the regulation on serious cross-border threats to health, with the agreement of both Council and Parliament, albeit without impact assessment on grounds of urgency, and to this extent will have attained democratic approval in the normal way in which this is given at EU level. It does seem strongly arguable that the overall vision for a health union in whatever form this is envisaged, will arguably need democratic sanction in a stronger form. The Conference on the Future of Europe may well have a role in proposing appropriate treaty provisions in this regard. And it appears that the Commission has in mind that if treaty change emerges, that it should not merely ratify or consolidate existing progress. The Commission has noted of its own proposals for what it terms the first building blocks for a European health union that, quote, these first proposals are envisaged within the current treaty provisions. And that's hinting fairly heavily at an anticipation of continued development of the treaty basis for health law. And indeed, it has stressed that the upcoming conference, with its emphasis on outreach to citizens, provides an optimal platform to ignite discussions and provide impetus on the EU's role in health in the future. Observation number 5, and my apologies for ending on a slightly darker note, in the future evolution of European health policy, a number of overlapping challenges, I think, will clearly have to be faced. And the challenge will clearly have to be faced. The challenge of ensuring that democratic control is maintained over health policy, the challenge of avoiding unsystematized competence creep, the challenge of ensuring that the full spectrum of interests involved in the health field are properly represented at European level, and that rights and values are not bypassed. The challenge of ensuring that the EU will not become a bull in the China shop in an area of extreme sensitivity at national level. The challenge of ensuring that the financial market and indeed political power of international corporations in the medical or pharmaceuticals field can be kept under control. And the challenge of keeping technocratic decision-making by committees, agencies, and by expert groups under adequate judicial and democratic control. And finally, there is, of course, the challenge of ensuring success. In other words, of the European Union meeting the challenge of safeguarding and promoting human health. Okay, I've gone on for perhaps a little bit too long, but I hope that has been of some interest, maybe in introducing some of the themes and some of the issues that can be developed on in further detail by some of the other speakers in the course of this webinar.
Thank you very much, Professor Barrett. Thank you for this extremely insightful presentation and for leading us quite naturally to the topics that we're going to discuss in our subsequent panels. We have some minutes for discussion now, so if some of the participants have questions to pose to Professor Barrett, please go ahead and write them on the chat now. And to all the speakers, if you have any questions, just go ahead, open your microphones and ask.
Yeah, I'm as grateful for contributions as I am for questions, because I have status of a discerning dilettante, I think, in this area. And so any other contributions are very welcome as well.
May I ask a question? It's Sabrina speaking, sorry. Thank you very much for that very insightful presentation and the difficult job of really bringing all of the EU responses into one presentation, which is remarkable. I really liked your the challenges that you identified actually coming forward from that. You already alerted to the potential of an unsystematic competence creep or uncontrolled competence creep, let's say, that we might face as a consequence of the response on the institution building and so on that you have described. I was wondering if in the responses that you have seen already now in the crisis and that you have elaborated on, do you already see a competence creep there? And I'm asking that question very much in the context of the very extensive use of executive rulemaking and soft law responses, actually also in fields where the EU traditionally would leave more competences to the member states. Let's say, for example, when we speak about the vaccines, I find quite remarkable in how far the European Commission has adopted a communication on the vaccination strategy and has been very much on top of trying to streamline the vaccination strategies of the member states by soft law means and by command and control means, not so much in sense of legally binding measures. So would you say that there is already an ongoing competence creep as a response to the COVID crisis?
I suppose yes is the answer to that. I suppose gradually over time, you know, there has been this accretion, if you like, of powers, and that's not necessarily for any any evil or wrong kind of reason. It's just that I suppose problems arose, the solutions needed to be found to those. The solutions were found at European level, and just whatever resources could be used, institutional resources, whatever legal resources could be used, and were used and were deployed in dealing with those. But I think there is a certain extent, I think, to which that has gone on for a while, and perhaps it would not be a bad time to get some treaty legitimation. So, for example, there are a lot of institutions now, and I don't mean formal institutions like the Commission or the Council, but there are a lot of agencies, a lot of bodies which are being set up at the moment. And I don't think it would be any harm to if you like, to have the broad directions of policy, you know, the more important perhaps of the institutions enshrined in treaties, if you like, and given you know, the clearest possible sanction by member states that involves. I think that would be desirable, so that I think that, you know, is something that you know, that could be a task for the conference on the future of Europe, if you like, ratification, if you like, of democratic validation and ratification of things that have already taken place, as well as perhaps reflection on things that should take place in the future. So that, for example, the view might be taken at this stage that you know, a greater capacity for legislative harmonization in the health field should be allowed. That might be proposed as well. So, you know, I think you know, treaty change should probably, as I said, you know, have a backward-looking aspect to it and a forward-looking aspect. The backward-looking aspect being the approval of things that have taken place already, and the forward-looking one being planning for perhaps a greater role in the health field than was certainly originally envisaged by the treaty drafters, I think.
Now, if no one wants to ask, I will abuse a bit my power of initiative and ask you something which is related to what Sabrina just asked. We've seen that there's room for the European Union to make things, and there's a matter of political will mostly. And I would like to know what you think about the role of the court in this, because the history of European integration is one of developments in moments of strong political coordination. And then we've had some other moments in which it is the court who through its creative case law, fosters the development of a certain area of EU law. And I'm in connection with this, I would like to know whether you think the court will likely or even should revisit its admissibility case law concerning soft law measures and composite administrative decisions. I'm sorry, I posed two questions in one.
Yeah, yeah. I mean, the role of the court has been important, and in fact, perhaps like other areas of law, perhaps to a greater extent, the development of law in this area has been driven by crises from time to time, and you know, you know, occasionally there have been decisions by the European Court of Justice, which have, you know, later been, if you like, ratified in treaty changes then afterwards. You know, so the court has played its role in that regard, and there have been very important decisions of the Court of Justice in areas like, for instance, establishing the general, you know, various general principles, the general principle, if you like, of the importance of action in the health field, or the importance of health protection, and its priority over over economic considerations. That has been very important. We've had decisions like the decision concerning the invalidation of the Tobacco Advertising Directive. That was a hugely important step as well. If I recall correctly, it was the first time a measure was ever declared void at European level, and it, you know, it established, if you like, or clarified the relationship between free market provisions, or internal market provisions, I should say, and health measures. So that's another area where it has been important. And you know, other general principles or decisions of the court in fields like proportionality and non-discrimination have been very significant as well. So there've been a range of really important contributions by the European Court of Justice. Yeah, I mean, a maximized role for the court, even in relation to soft law measures, I think is appropriate, because I think the necessity for democratic control and judicial control in this area is extremely important. As I identified, one of the main challenges here is maintaining democratic control in this area. I suppose there's a great temptation because a lot of the solutions in this field are technocratic in nature, to hand them over to the technocrats, and yet it's a vitally important area, a very sensitive area of public policy, and therefore it is one in which it is appropriate that adequate controls be exercised.
Is there any other question? In this case, we're going to proceed with the first panel. We thank you again, Professor Barrett, for your splendid presentation, and I'm going to give the floor to Professor Jeff King again to chair this first panel on COVID-19 vaccination, rights and freedoms. Professor King is Professor of Law at UCL London, and as said before, he's co-principal investigator with Professor Octavio Ferrat of the LexAtlas COVID-19 project. He is currently a legal advisor at the House of Lords Select Committee on the Constitution and a visiting professor at the Faculty of Law, University of Oxford. He sits on the editorial committee of public law, the General Council of the International Society of Public Law, the ICON Society, and he's a member of the Study of Parliament group. His book, Judging Social Rights, published by Cambridge University Press in 2012, won the Society of Legal Scholars 2014 Peter Birks Prize for Outstanding Legal Scholarship. Jeff, thank you very much for being here, and you have the floor.
It's an honor. As I said already, I just wanted to point out to Professor Barrett that there were 2 additional questions for him in the chat box, which may be worth answering. I think at the moment, with apologies to Johan and Alessio, we're going to proceed, otherwise we'll fall too far behind in the schedule. So I was also asked to, prior to introducing our speakers for the panel, to say a word or 2 about the LexAtlas COVID-19 project. I just want to be extremely brief in this regard. You can visit our website. Everything is explained there. There are about 150 scholars collaborating in this project, and you can see the aims and the outputs of the project there. The major outputs are the Oxford Compendium of National Legal Responses to COVID-19. And I wanted to mention that all of these national country reports are put together according to a comprehensive author guidance code. You can find the same answers to the same questions about the same themes in exactly the same place in every report. They're all designed to the same structure. So it's designed to facilitate comparison for an audience like this. And we're dealing with elements of constitutional law, public health measures, social policy and employment policy, and human rights will be added very shortly. And these reports will be updated over the course of the coming year. So that's the provision of information part. We'll also be doing analysis within the project, which would include blog symposia, insights and reports on particular topics. And then finally, the editorial committee will do a major report on the whole experience, where we'll be making suggestions about best and worst practices. So I just wanted to say that the amount of work that went into producing the country reports and editing them to ensure comparability was massive. And I would invite any person listening to this seminar to have a look, because I think it will interest you. So the topic for our panel is COVID-19 vaccination, rights and freedoms. And on this subject, there are essentially 2 major topical sites. And I say this as someone who coordinated a blog symposium on mandatory vaccination for LAC-19. One of the sites of interest is mandatory vaccination or vaccination conditions in the public or private sphere that are enforceable as mandates, de facto or de jure. There are a large number of rights considerations that go into that. And we'll be hearing on exactly this subject from Dr. Diletta Tega whose work on this area is already incredibly impressive. And I know from discussing this topic with her that she's incredibly well informed. The other area, of course, is travel and vaccination passports. And we're very honored to have Professor Dimitry Kochenov come and speak with us about this subject, who has a forthcoming article on it, and lots of experience with the theme of citizenship, as I'll make clear when I explain what his background is. So these are two highly distinguished jurists that we have with us. We're delighted to host you. I just wanted to say a few more words about Dr. Tega's background before she begins with her presentation, which we should keep to about 18 to 20 minutes, if you can, Diletta. So Dr. Tega is an associate professor of constitutional law at Bologna University and a visiting professor at the law faculty at the University of Antwerp in the 2020-2021 academic year. She's also the vice president of the bioethics committee at the Bologna University and is, I'm very happy to say, a member of the LexAtlas project. She also sits on the General Council of the International Society of Public Law, ICON-S, and is Secretary General of the ICON-S Italy chapter. And she sits on the editorial board of the distinguished journal Quaderni Costituzionali. So I don't think, if I kept going on exploring other elements of your bio, Diletta, I think we'd be here for a long time because it's a very distinguished one. Why don't we hand over to you and hear you speak about our theme today?
Thank you very much, Jeff. Thank you all for the invitation. It's really a pleasure to be with you today, to join new and old friends. The organizers asked me to discuss how fundamental rights in the EU.
Diletta, I'm sorry to interrupt you so soon, but I just wanted to mention what I'm going to do is when there are a few minutes left in your presentation, I'm going to turn my camera back on as an indication to you that there's about 2 or 3 minutes left in the time.
Okay, great. Okay, Jeff.
Thank you.
So as I was saying, the organizers asked me to discuss how fundamental rights in the EU could condition national policies imposing vaccination mandates or making vaccination, let's say, a condition to fully exercise certain rights or freedoms, as Jeff said, about work, travel, education. Now, I do that from my perspective, let's say from the perspective of a constitutional law scholar. But before doing that, let me do a very short, small consideration on the title given to my presentation. It recalls the traditional dichotomy between freedom and obligation. Fine, it's correct. But pandemic casts a new light on such dichotomy. The existence of several vaccines against COVID-19, together with the severe outcomes of the disease, made us consider the inoculation of those vaccines almost as a right. The idea that the vaccination is a right of the individual opens up several reflections, which I'm not going to address now, but let me address just one very shortly. We have to confront the fact that entire continents do not have access to the anti-COVID vaccination. Turning to my presentation, I'm not going, Jeff, to go through the complex discussion about the different meanings that compulsory vaccination has in different national legal systems. We all know, I don't know if you later you want to touch it, but we all know that there is a huge spectrum, let's say, of policies, of national policies on vaccination of children in particular that are very different. They ranging from one based wholly recommendation through those that make one or more vaccination compulsory, to those that make it a matter of legal duty to ensure the complete vaccination of children. It's an interesting topic, but it's let's say it's something that I have to skip, but I hope that Jeff, you may touch it maybe later. Now, the assumption shared traditionally by European states is that vaccination, and in particular childhood vaccination, is a fundamental aspect of contemporary public health policy. There is a general consensus among the contracting parties of both EU and the Council of Europe, strongly supported also by the specialized international bodies, that vaccination is one of the most successful and cost-effective health interventions, and that each state should aim to achieve the highest possible level of vaccination among its population. Historically, UK was the very first country to pass a legislation on the compulsory vaccination against smallpox, if I'm not wrong. Nowadays, there is not compulsory vaccination, though, in that legal system. And then the attention on that aspect of public health spread all over Europe. And finally, it has been inherited by the so-called European standards of human rights protection. Now, basically, those standards put at stake the value not only of public health, but also, more generally speaking, of social solidarity. Of course, in particular, here, the purpose of the duty being to protect the health of all members of society, and particularly those who are especially vulnerable with respect to certain disease, and whose behalf population, and on whose behalf population is asked to assume a minimum risk in the form of vaccination. Here, I'm basically quoting a resolution of 2011 taken by the Parliamentary Assembly of the Council of Europe. Now, we know very well that often compulsory vaccination is challenged at the national level on a number of grounds, including as an unjustifiable interference with the constitutional guarantee of individual autonomy and respect, of course, for private life. Now, quite recently, national constitutional courts, such as the Conseil Constitutionnel in 2015, the Czech Court, the Czech Constitutional Court, again in 2015, the Italian Constitutional Court in 2018, elaborated on such interferences, stating that they are necessary for the public health and the best interest of the child. The necessity of the interference has been assessed in the light of the state's positive obligations to protect life and physical integrity of those within national jurisdiction. Now, the Wawrzyszka decision, I don't know if I pronounce it correctly, of last April showed that such interference is challenged as an interference against Article 8 of the European Convention. Now, from my perspective, that decision demonstrates that there could be a very productive dialogue and exchange among national constitutional courts and national legal system and the Court of Strasbourg. Indeed, the European Court builds her conclusions on the national findings made by the constitutional courts I have already mentioned. It seems to me that the aspect of protection of public health through vaccination can be the example of a real, let's say, pan-European constitutionalism in which national legislations and national courts, national constitutional courts, to work with the European counterparts to define and strengthen health guarantees. Now, both levels of protection, let's say national and supranational, national and European, are worried of vaccine hesitancy and are worried about the drop in vaccination rates in Europe. And they share basically the same recommendation, that is to strengthen cooperation against the vaccine preventable disease. And these recommendations recognizes that vaccination is one of the most powerful and cost-effective public health measures developed in the 20th century and remains the main tool for primary prevention of communicable diseases. So I really see that there is this kind of sharing attention and sensitivity. Now, coming to the Wawrzyska decision, it represents a complete summary of the different European and also international human rights standards, okay? So I'm not going to speak about those because you can find basically the index if you go through paragraph 1 to 129 to 151 of the decision. There you will find the mention of the European Social Charter, you will find the mention, of course, of the Oviedo Convention, you will find the mention of several recommendations made by the Parliamentary Assembly of Council of Europe, as well as the mention of the Article 168 about public health of the Treaty on the Functioning of the EU, and of course, the mention of Article 35 of the Charter of Fundamental Rights. I'm not going to, and of course, you will also find several resolutions made by the European Parliament. As I said before, I suggest you to go through the paragraphs I mentioned, and what it's important for me to underline is that all these European standards share the same attitude regarding the importance, the centrality, the cruciality of vaccination. Now, having said that, I have done for you a kind of checklist of at least 6 items in which each point made by the European Court in the Wawrzyska case could be considered, in my opinion, as a standard of protection, also shared by national case law and legislation. So first of all, and in my opinion, that is the crucial point of the decision, there is a general consensus expressed by not only the national constitutional courts I mentioned before, but here in the Wawrzyska case expressed by the European Court, that a general critical opinion on vaccination does not constitute the expression of conviction or belief in order to get exemption from vaccination. A critical opinion has to be of sufficient cogency, seriousness, cohesion, and importance to attract, in order to attract the guarantees expressed not only by national constitutions, but of course the guarantees developed in Article 9 of the Convention. And here the European Court states, for example, the Czech Constitutional Court, no too much space, let's say no space for no-vax positions expressed in a very general way. And in my opinion, considering also my legal system, the Italian legal system, I find that is the crucial message of the Wawrzyszka, the crucial standard that I really want to say first. Now, second, healthcare policy matters come within a wide margin of appreciation. The court takes the view that in case of the compulsory nature of child vaccination, because again, as you all know, the Wawrzyszka decision is not about anti-COVID-19 vaccination. Okay, we speak about compulsory child vaccination. Now, the margin should be a wide one. And the court, the European Court, has held that matters of healthcare policy are in principle within the margin of appreciation of the domestic authorities, who are best placed to assess priorities, use of resources, and social needs. Third, states to place the best interest of the child and also those of children as a group at the center in their health and development. So when it comes to immunization, the objective should be that every child is protected against serious disease. Fourth, domestic authorities may reasonably introduce a compulsory vaccination policy in order to achieve an appropriate level of protection against serious disease. Fifth, the objective are to protect against diseases which may pose a serious risk to health, both to those who receive the vaccinations concerned, as well those who cannot be vaccinated and are thus in a state of vulnerability, relying on the attainment of a high level of vaccination within society at large for protection against the contagious disease in question, corresponds to the aims of the protection of health and to the protection of rights of others, recognized by Article 8 of the Convention and recognized also by national constitutional provisions related to the right of health. Now, sixth, referring to a decision in particularly taken by the Italian Constitutional Court. It's a decision that the European Court quotes. It's a decision on compulsory vaccination of 2018, as I said before. The European Court found that the issue of vaccinations involves many constitutional values, of course, the coexistence of which left room for legislative by which to ensure the effective prevention of infectious disease. Now, that discretion, that political discretion, has to be exercised in the light of the various health and epidemiological conditions, as ascertained by the responsible authorities and of the constantly evolving discoveries of medical research, the importance of scientific doctrine, to which the legislature had to turn for guidance when making its choices in that area. And here I quote two lines by the Italian Constitutional Court, quoted by the European Court. Naturally, nothing prevents this choice from being reevaluated and reconsidered should conditions change, as the medical and scientific knowledge that must shore up regulatory choices in the healthcare field as an intrinsic evolving dynamic. Now, I'm going to conclude. I would like to say that I believe that the most important contribution to constitutional doctrine can offer on that topic is to contribute to design a proportionality test to be used in judicial cases on mandatory vaccination, not only on childhood vaccination, but of course, for the future regarding anti-COVID-19 vaccination. I'm not speaking about coercive vaccination, okay, because this is an extreme case, and I don't think that there is any national system that opted for this model. But of course, if and when we are going to speak about coercive vaccination, of course, on the table, we have also the habeas corpus guarantees, but I'm not going to refer to this kind of model. Now, coming to the test of proportionality, exactly because we have many fundamental rights at stake and many values, of course, I would like to mention that constitutional courts, national constitutional courts, had the chance to develop a proportionality test again regarding childhood compulsory vaccination. And I think that it could be interesting to recall it because it could be useful also for the European Court of Strasbourg. Now, basically, a law imposing a health-related treatment is not incompatible, for example, with the right, with individual autonomy, personal life, and autonomy also regarding the choices about health, when the treatment is intended not only to improve or maintain the health of the recipient, but also to preserve the health of others. 2, the treatment is not expected to have a negative impact on the health of the recipient, with the exclusive exception, let's say, of those consequences that normally. Lastly, in the event of further injury,
you froze on my screen with your second point or your third point. I've forgotten which, but the last point you just made, if you could restate it briefly for us, then I think that'll help.
Yeah. So
same difficulty here. Froze here again as well. Diletta, you are frozen again. What I propose to do is
injury?
you're
the pain.
Pardon me, Diletta, you are frozen again, and now it seems for a third time. Perhaps we can come back to you after we've heard from Dimitry, and you can restate your views on how we can derive insights about the application of the proportionality principle to this issue. Okay. While we're getting that connection difficulty worked out, I think we were quite close to the end of Dr. Tega's analysis, and we will pick it up after we hear from Dimitry just now. So I'd like to introduce our next speaker.
Can you hear me?
I can hear you now. Yes, maybe with your camera off, that'll improve your connection, and you could wrap up.
Yes, I'm really sorry. Just 2 more minutes, Jeff. It's possible. So the last issue, let's say, the last items of the proportionality test, as I said, in the event of further injury, the payment of just compensation to the injured party is provided for, separate and apart from any damages to which they might be entitled. All I have, all I have said regards compulsory vaccination in general is not, of course, related to vaccination against COVID-19. We are still waiting for judicial decisions on that point. But as you know, as you may know, the Italian legal system has been the first country, as far as I know, to enact a law specifically prescribing COVID-19 vaccination for healthcare workers, with no compliance entailing removal from healthcare activities, or when this is not possible, suspension from work and wage. So I am expecting that this legislation could be challenged in front of the Constitutional Court, but also in front of the European Court of Strasbourg. So maybe we may be the first to see and to test if the Wawrzyszka decision and the content of the Wawrzyszka decision, the checklist that I have enumerated, can be useful, can be helpful in dealing with the anti-COVID-19 vaccination compulsory for healthcare workers. That's my reflection. And if I have just a few seconds, I would like to suggest a couple of readings. I would like to suggest a book edited also by Dolores Utrilla, EU Law in Times of Pandemic. You can find there a chapter on this topic. And I have also found an article on the ICL journal by Anja Krasser, Compulsory Vaccination in a Fundamental Rights Perspective, Lesson from the European Convention of Human Rights. And it's interesting because the author tries to reflect on the possibility of interpreting the European Convention regarding an hypothetical case on the vaccination against COVID-19. Thank you very much.
Thank you very much, Diletta, for that fascinating discussion. And people listening are welcome to type some questions into the chat box as we go. I'll be listening to our next speaker, but you can have some time to think about what you want to ask and write it out there. We'll come back to it. So our next speaker is Professor Kochenov, who leads the Rule of Law Working Group at the Central European University Democracy Institute in Budapest, and is a professor of legal studies at the CEU in Vienna. So he specializes in citizenship and the principles of public law, and he's taught citizenship and the rule of law at many institutions worldwide, from Princeton to Osaka to UNAM in Mexico and in Oxford. He is engaged by governments and international organizations frequently and sits on a range of editorial boards, including the Hague Journal of the Rule of Law. And his latest monograph is entitled Citizenship, published by MIT Press in 2019, and has already been translated into several languages and reviewed in the New York Review of Books, which must be a high point on any scholar's bucket list. So I'm very delighted to invite Professor Kochenov to speak about vaccination passports and free movement. And as I'm sure he will clarify, this is in connection with forthcoming publication. So over to you.
It's so kind of you, Jeff. Thank you very much. And thank you to the organizers for the kind invitation. In fact, there is no topic which would be more topical, as it were. So I'm extremely pleased to be here. In particular, so because I have been fascinated by passports all my life, and this is what I have been studying: passports and citizenship. And suddenly, the pandemic reality has amplified the importance of this correct documentation of the European population. And I see the latest developments in this regard, especially this COVID certificates, which are being introduced around all the member states via this regulation, as deeply problematic. So what I will be speaking about is why this basically should not have been done this way. And I speak based on the article which I have just shared, which hasn't been yet put up by the European Journal of Risk Regulation, but which has been submitted already months ago. So it might be not entirely up to date, but all the basic ideas are there. And the article was co-written with a friend from Cambridge, Jacqueline Viraldi. And I see that there are plenty of amazing people in the audience, with many of whom I agree, with many of whom I disagree. But the person I would like to pinpoint is Oscar Stein, who is in Friesland, and with whom we have also authored a working paper for Compass Oxford on exactly the same issues, which I would like to invite everybody to read. But the basic premise, and I will be very brief, is that the internal market is well known to all of us. What is the internal market? The internal market is a space without internal frontiers, where the free movement is unrestrained, and where competition abuses are made impossible. So if we take that as the starting point, as the guiding star of how we should regulate in the times of the pandemic, then what is being introduced via the regulation on COVID certificates is a very strong departure from the very baseline of what the internal market is about. And that departure presumes that you can actually further the interests of the citizens in participating in the internal market. You can open up the borders in the union by precisely introducing a document that will need to be checked at all those borders. So the starting assumption is oxymoronic, because if we want to open up the Austrian Republic, then certainly nobody would suggest that new borders should be introduced between Vienna, the capital land, and all what surrounds it. And that certainly we wouldn't introduce a document that will be required in order to take a train to Salzburg. So using this national level comparison is probably helpful to see the absurdity of the European approach. And the absurdity of the European approach consists in demonizing European citizens coming from outside of the border between the member states that the internal market, that the treaties have pledged to abolish by introducing the concept of the internal market. So there is no logic behind the COVID certificates, as long as COVID certificates as are being introduced are not serving the same purpose within the national contexts in all the member states. And of course they are not, because no member state, once again, at this point, enforces, to my knowledge, a policy of strict border controls between different parts of the member state based on some kind of national COVID certificates. So what we see is a departure from the principles of the internal market. And having said that, it becomes absolutely clear that the Commission has definitely chosen a wrong legal basis for what it has proposed. And of course, I will be rehearsing all these hesitation points that Gavin has already kindly mentioned in his amazing introduction. So I don't want to sound too negative, but it seems to me that many of us would agree that from the first days of the pandemic, when it became really felt in the European Union, suddenly the European Union has withdrawn from its task of regulating the internal market in terms of free movement of persons. So suddenly people cannot anymore travel anywhere in the EU. We're speaking about March, we're speaking about April 2020, and the Commission is doing nothing. So no clear justifications for full closures were offered by the member states, and when they were fully paralleled by national restrictions, then that was probably fine. But in the absence of such parallelism, it's deeply problematic. So what we see with COVID-19 certificates, we see the continuation of this kind of idea that actually closing the border and keeping it closed unless something or until the point when some document is produced or something extraordinary happens is fine. And this is not a correct starting point for thinking about the subject as we suggest with Jacqueline in our paper. And then if we start digging behind what the Commission actually suggested and what the co-legislators managed to adopt, it's clear that there are more problems, that actually the way how the COVID certificates are organized is so archaic that indeed it predates the main principles of internal market law, in that it does not necessarily rely on full mutual recognition between the member states, and that in fact the supranational measure, the regulation, has departed from established principles which would apply otherwise to medicines and to the four types of free movement. And I explain why I think this is what has happened. The trouble with the certificate on this count, and I'm already past the criticism of the certificate on the basis of the principal departure from the basic idea of a borderless internal market. The second problem is that the certificate actually prohibits member states from issuing such certificates based on nationally authorized vaccines received by the population, and thus prevents the member states from attesting to effect of scientifically sound immunization. And how does it work? In the first draft that the commission proposed, it was entirely up to the member states what kind of vaccines they would put on the certificate, and then other member states were either obliged to accept the certificates or could have their concerns and would thus not accept the certificate. So what was supposed to happen? Let's take Hungary as an example, where my institute is based. In Hungary, plenty of people received Sputnik vaccines and Sinopharm vaccines during the time when the European procurement policy was causing grave delays, which could result and resulted in mass deaths. So in order to prevent that, the government procured other vaccines elsewhere, the vaccines which were not produced or yet authorized by the EMA or the World Health Organization, and those vaccines were being tested just like any other, and they were fully lawfully put on the local market and administered. So the same provisions of EU law were used by the UK before the Brexit date in order to put Pfizer on the UK market, to start inoculating people with Pfizer in the UK as Sputnik in Hungary. And then what was supposed to happen as EU law as it stood back then would suggest is that once the fact of inoculation is proven by a certain official document, other member states would need to accept this document. And this is something that the first draft of the COVID-19 passports regulation was actually opening the doors to. And then comes the European Parliament with amendments that would actually prohibit the member states from issuing COVID-19 certificates based on the vaccinations with the use of the vaccines which are not EMA approved, which means that what the Parliament proposed and what ended up in the regulation actually departs from the way how EU law used to function since forever, pretty much, because the law prescribes the law basically makes it absolutely indispensable for all the medicinal products which are in use in the member states and which could be effective via the fact of vaccination across borders, to get also European clearance and national temporary authorization would not be enough. So what are the effects of that? We know the science behind vaccines. We have Lancet publications. We have large scale studies that state that all the vaccines that were administered, for instance, in Hungary, are absolutely effective. So if you look at the effectiveness of the Sputnik vaccine, it's very similar to Pfizer or AstraZeneca, if not better in terms of the side effects. So in terms of health, it is impossible based on health data to make an argument which would be consistent with the idea of health hazards and protecting ourselves from health threats. It would be impossible to make an argument that someone who is inoculated with Sputnik is a threat. Yet this is exactly the message that European level regulation is sending, because the member states are prohibited from issuing certificates to this kind of people. Of course, it's in direct discrimination on the basis of nationality, which is in the regulation. So the regulation tries to undermine the basic starting point of the internal market, and then while doing it, it also introduces nationality discrimination. Why? Because not all the member states obviously use the same vaccines. And if someone is inoculated with a Sputnik vaccine, most likely that will be an EU citizen of Hungarian nationality. So the targeted geopolitical understanding of Sputnik being bad, that translates into the problems with someone's particular nationality, because usually we cannot choose our vaccines, becomes a huge problem. And then as a result, we have an instrument which is now binding on all the member states, that instead of promoting easier travel across the borders without any discrimination, adopts a strange geopolitical approach to the understanding of health threats, and allows member states, prohibits member states from attesting certain facts of inoculation, which medically speaking are not in any way different from inoculations with other vaccines. And at the same time, it allows other member states not to acknowledge at all any kind of alternative documents which would be issued by the member states using non-standard vaccines. And there is a footnote: non-standard vaccines are, of course, the non-Western vaccines. So when we look at the lists of vaccines which have been approved by the World Health Organization at the moment when the regulation was first introduced, when the proposal was first introduced, there was not a single non-Western vaccine there. If you look at the numbers around the world and the deployment of different model vaccines, you will find instantly that there are actually non-Western vaccines which are A, effective, and B, they're deployed en masse on different continents all around the world. But this happens to be the third world, or the second world, if you as it were, the former Soviet Union, Brazil, Argentina. These are the countries which are mostly inoculated by those vaccines. And then the third last point, all the European citizens who permanently reside or who happen to be stranded long-term during the pandemic in all those parts of the world are then not entitled to this COVID-19 certificate under the regulation, simply because they got the wrong inoculation. So our conclusion is that the pandemic is first, the pandemic showed the actual power of the member states to disregard the ABC of the internal market and free movement of people, sometimes without any kind of logically demonstrable reason and without any kind of health grounds, which would be even remotely convincing. And B, the Commission is now trying to regain its overwhelming powers actually in this particular field, but it's trying to regain its powers by taking a step back from the basic floor of regulation, which we thought until the moment when the crisis started slightly more than 1 year ago was absolutely guaranteed for all of us. So all Europeans suffered as a result, and what we see is not good health regulation. It's a geopolitically tinted, haphazard attempt by the Commission to convince the member states that actually the internal market and free movement of persons should be put back on track, and the Commission has not been overwhelmingly successful in doing that. Thank you very much.
Thank you very much, Dimitry, for that excellent presentation, and with a clear position that I'm hoping some people will take you up on in the discussion. That will give us everything some additional vigor. So we already have a question for Dr. Tega. I'd like to open the floor for discussion, obviously now, and also if we can go on for the next 10 minutes. We'll eat slightly into our break, but I think it's appropriate in this case because we began a few minutes late. So we have a question from Richard Goldberg, an expert in this area, for Dr. Tega. He's interested in the role of compensation to those injured by vaccines and the exercise of the proportionality test that's been suggested by Diletta. Could you expand on that briefly?
Yes, thank you. Can you hear me?
Yes.
Yes. Listen, compensation is provided also in the new piece of legislation that was enacted last April in Italy in order to provide for mandatory vaccination for healthcare workers. To my knowledge, the reflection on compensation was addressed also by the Czech Constitutional Court and the Czech legislation, and of course also in the Wawrzyszka case, the European Court elaborate a little on just compensation. And as far as I know, also the Italian Constitutional Court decision 5 of 2018 on mandatory vaccinations again consider the just compensation one of the three items of the proportionality test. Now, I cannot elaborate more on just compensation in the sense, let's say, in the meaning that the Constitutional Court does not consider if the compensation provided by the legislation is proportionate, okay? The Italian Constitutional Court, and as far as I remember, also the European Court in Wawrzyszka, let's say, are satisfying in detecting that the legislation provides the just compensation. To my knowledge, they do not go deeper, let's say, in discussing the amount, for example, of the compensation.
Okay. Yes, have you finished your your answer? Okay, great. Thank you. I hope that was helpful for Professor Goldberg. Okay, we have another question for Dimitry Kochenov from one of our participants. Sabrina, perhaps you can just turn your camera on and ask the question, which I'm fascinated by.
With pleasure, with great pleasure. Thank you very much for the presentation. I had read the draft paper already and was really excited for this. Now, I don't disagree with the political context that you have presented. Absolutely not. But what struck me already when I read your paper was that I think in terms of the representation of how mutual recognition works in terms of pharmaceutical authorization, one should add that actually this D'Assonville mutual recognition, the very automatic one of the free movement of goods that are legally produced in one member state to be recognized in another, does not work like that in the pharmaceutical context. Right? We have the central authorizations that have been used for the COVID vaccines, 4 of the COVID vaccines. And then when you would mutually recognize any pharmaceutical, not just vaccines, but any pharmaceutical on the basis of a national authorization or a common national assessment procedure, which can also happen. It is a quite elaborate process. So one member state would actually do a scientific assessment, authorize, like Hungary did, right, for the Sputnik vaccine. So no question on the scientific basis of that or anything. I'm absolutely not in a position to say something about that, but it would never be that would be sufficient to bring that product on the market in another member state. But there is a quite elaborate procedure that they go through with all of the member states, where also member states have the opportunity to raise serious concerns with regard to public health in terms of refusing the mutual acceptance of that. There is a stage of EMA arbitration and commission arbitration in that regard. It's quite complex. Actually, I cut it out from my presentation that will follow later because it's so complex. But bottom line, there is no automatic mutual recognition of pharmaceuticals. Why would that be different in terms of the vaccination certificate? And I'm not saying that there are not reasons for it to be different, but why would that be the case? Because in essence, that's what you propose. Thank you so much.
Thank you, Sabrina.
That's a really amazing question, and I have to say right away that I'm not an expert in putting pharmaceuticals on the market. That was my co-author, and I absolutely trust her. She's almost done with a PhD on this. But what is the clear difference here is whether we can treat someone who has been inoculated with Sputnik as the exportation of Sputnik across the border into a different member state. Obviously not. So at least that would be my answer. So the emergency authorization in line with the directive in Hungary obviously creates someone who is absolutely safe in the eyes of the Hungarian state and also in the eyes of Lancet, etc. And it doesn't amount to the exportation of the vaccine when that person travels to Austria by train or takes, I don't know, or crosses any other European border. So the idea is that once something is considered as working and is lawfully marketed, and that means that in Hungary that vaccine, as a consequence of vaccination, should be accepted elsewhere. And this is what I meant by mutual recognition, because now the member states take their decisions seemingly absolutely haphazardly, because they simply decide whether they will accept the national vaccination certificates issued by the Hungarian government listing this vaccine or not. Hungary is notified, everybody knows where that person can or cannot travel, but no scientific reasons are given and no legal reasons are given. And in fact, they're not necessary because the regulation as it stands, as amended by the European Parliament, actually prohibits any kind of issuance of the European level vaccine immunity certificate. So what is the outcome of this? The outcome of this is that the regulation has produced national level certificates and European level certificates. There is no automatic recognition of national level certificates, and what we have to underline, there is no automatic recognition of European level certificates either, because imagine someone is inoculated with Sinopharm somewhere in Hong Kong, for instance. That person flies to, who is a European citizen, flies to one of the European Union member states, and then it will be necessary to look state by state, because Sinopharm is only on the World Health Organization safe list. But not EMA approved yet, correct me if I'm wrong, which means that the regulation doesn't create an obligation on the member states to recognize this kind of inoculation. So we have a hierarchy of 3 levels of threats only among those who are already inoculated, and then there is super threat, those who are not. So instead of opening the borders and helping Europeans to travel from one member state to another freely, the regulation creates a system of threats, which is a 4-level system. And then each particular level is activated differently at each particular border. So it's a total maze, which is extremely difficult to navigate for ordinary Europeans.
Sabrina, did you want to come back with anything very briefly, or is that fine?
No, I think it's fully convincing, and indeed, I guess the key to that answer is that, you know, you also accept other forms of, let's call it immunization, or the non-threat level as you have presented it, right? So I think that's the stronger argument than basing it on the mutual recognition part of the quality, safety, and efficacy of the vaccine, let's say. So that was just my comment on that. Perfect. Thank you so much.
Can I just ask, in that same discussion, Dimitry, does your argument turn on the fact that the Lancet has confirmed the viability or this efficacy of Sputnik? Or does it turn exclusively on its recognition by a member state as being sufficient?
I cite the Lancet study, of course, but for instance, there was no such. Again, I'm not an expert in vaccines as such, but I couldn't find a similar study on Sinopharm. But Sinopharm is already on the WHO list, which means that once we proceed as lawyers, we will need to look at legal authorizations. So Sinopharm has got a much higher level of authorization as far as the European legislator goes, for instance, but not the highest, because it's not yet EMA, not the highest for the EU. And then if we look at the number of countries that authorized Sputnik, it's always an emergency authorization, right? At the national level, then there are dozens and dozens of countries. The trouble is the majority of those countries happen to be really non-Western countries, some post-colonial nations, etc. So what all this points to is a deepening division of the world into the first world and the rest, as a result of the current pandemic. And someone has already mentioned that, and I think Gavin especially already mentioned that we have growing problems in this regard.
Excellent. Thank you very much for that. I think that we're going to circle back to Professor Barrett, who will speak briefly to some of the questions that were asked in the last session, which he was not able to answer for various reasons. If we can have quick responses from you, Gavin, and then we will take a break as per the schedule and resume in, let's say we'll resume at 5 after, I think will be appropriate, just so we can move things along in the same way that we have. Okay, over to you, Gavin. You're muted.
Sorry, yeah, thanks very much, Jeff. Yeah, just very quickly indeed. There was one question about, is there any equivalent of the Eurogroup in the health area for the Eurozone states? And my answer to that would be no, because the Eurogroup is basically, it's like a smaller version of the ECOFIN Council that exists in the economic field, that exists for states which are just Eurozone states. So it's the finance ministers or economics ministers of the Eurozone states, and there's no equivalent in health law, because there isn't a health group or a subgroup, I beg your pardon, of states in health law. So basically the equivalent body to the Eurogroup is essentially the EPSCO Council, the Employment, Social Policy, Health and Consumer Affairs Council configuration, and that meets 4 times a year. Although on 2 of those occasions it meets only on social and employment grounds, so there won't be health ministers there for at least 2 of those meetings. So it's quite a rarely meeting body, but insofar as it does meet, it's subject to all the usual requirements. If it's adopting legislation, it has to meet in public, and obviously minutes are produced after it, and agendas are set out beforehand. So no direct counterpart there. Health being a right or a principle, I must admit I didn't bring my textbooks with me, so I have actually forgotten Article 35 of the Charter of Fundamental Rights of the European Union. The questioner says that is regarded as being a principle rather than being a right. I have to admit, my memory escapes me in relation to that. It's certainly phrased as a right in the Charter, or described as a right in the Charter. The explanations refer to the principles that are discussed in Article 35, but I think that just means the rules as such. So I'm not 100% sure that it is only a principle. Perhaps the questioner is more expert than I am in that regard. As to whether there's anything else that could be considered a right, I suppose there is the general principle in this regard, and one has to remember that general principles are constitutional level principles, and that they are directly effective as well. That has been held to be the case, both vertically and horizontally. So perhaps to some extent they can be regarded as the equivalent to that. But a very good question, and thank you for it. If I could just add one little point there, Dimitry, if I quibble just for a minute, my understanding in relation to the certificate basically was that that the member states can rely on health grounds, if you like, to block, we say, the free movement of persons. And my understanding of the certificate was that it was meant, if you like, to facilitate the free movement of persons, in the sense that if you have this certificate, if you can wave it in the face of whatever officials are checking you, if you like, they're deprived of a reason for you to move from one state to another. So if you like, the hand of proportionality and health protections that they can play is ripped out of their hand, just in relation to people holding this certificate, but that other people maintain their rights, which they had anyway. So if you like, they're not given this extra card, but they had whichever cards they had already, so that you know, they're entitled to rely on all the rules that existed there before in order to defend their rights of free movement. It's just that they don't get this extra right that is provided, this extra procedure that is provided by the digital COVID certificate. Have I misunderstood that then? Is that
Can I answer just very quickly,
Sure. Please do.
To my mind, all our rights have evaporated when the pandemic started. So free movement of persons came to a halt, and the worst of it was around this winter with compulsory hotel quarantines, with extremely expensive tests, sometimes 2, sometimes 3 tests required, depending on how many times you change planes, etc., and which airline you fly. I traveled a lot during the pandemic, unfortunately, and I always complied with the local regulations. But it was a horror story, and it really costs a fortune to travel these days. So this certificate, given that it's not given to all those who are inoculated, and it doesn't oblige all the member states to recognize all the vaccines, as such, besides the fact that it doesn't actually help by opening the borders, because someone will have to check the certificate, it creates a situation where health grounds are misused in order to justify some geopolitical considerations and other concerns that the member states might have, should the member states want to keep the borders closed. And of course, if we look at the actual regulation on the ground, as it stands, the member states which are more minded to welcome others do that without any kind of European certificate. So if we look at Greece is now much more open than many of other member states would be, and it's not because of the Commission's initiative and this regulation, but because of Greek national law. And ideally, it should be the Commission who would be proposing the more permissive regulation rather than Greece, because the Commission is in charge of making the European Union work. So this is why I bemoan. I find it a set point in our free movement story.
Okay. Thank you for that. And thank you to our panel more broadly, and again to Professor Gavin Barrett for 3 outstanding presentations in the first portion of today's webinar. It's been, I've learned a tremendous amount from it, and I'm sure everyone listening has. So we do have a break scheduled in the proceedings, and I'd like to suggest if we could reconvene in just over 20 minutes in order to hear the remainder of the talk, where we'll hear from Professor Sabrina Röttger-Wirtz and Mikko Huttunen from the European Commission, and then closing remarks by Dolores Utrilla. So if I can recommend that the panelists just turn their cameras off and go on mute, that would be great. And perhaps I believe we're saying goodbye to Professor Barrett. Are you on your way?
I might be able to get, thanks Jeff, I might be able to get just the first couple of minutes, but I'll have to leave fairly shortly into the next one. So please excuse me for that. I would love to stay, and I look forward to seeing the recordings of them afterwards.
Thank you. Thank you again. I'll see everyone in 20 minutes then. Thank you.
Thank you.
Hello, welcome back. We are going to start with our second panel, which focuses on the market of COVID-19 vaccines. And I have to start by apologizing on behalf of Daniel Sarmiento, Editor-in-Chief of ELL Live, who was going to chair this panel, but had a last-minute urgency and couldn't make it to the session. I will try to fill the void he's left here. Now we are moving to the consideration of COVID-19 vaccines in the market, which involves moving to the core of EU law. From the perspective of vaccine authorization and distribution, the European Union has proved to be, in general, well equipped to face many of the most pressing needs of the past months, in particular through its highly sophisticated sets of instruments relating to internal market law, which have been used in a flexible way where necessary. I won't go into this because this will be explained by our panelists, but I would like to open this session by pointing out the point that COVID-19 vaccines are becoming a true test bed for EU administrative law in general and for the administrative law of the internal market. And this is what we'll be addressing here today. We will be starting with a presentation by Sabrina Röttger-Wirtz, who's an assistant professor of EU law at the Faculty of Law of Maastricht University, and who's also a member of the LexAtlas COVID-19 project, as mentioned before. Sabrina was previously an assistant professor of EU health law at the Tilburg Institute for Law, Technology and Society, and she joined the legal service of the European Medicines Agency as a trainee and later as a contract agent. Sabrina is also the managing editor of the European Pharmaceutical Law Review. She is a steering committee member of the Young Researchers Platform of the Academic Research Network of Agencification of EU Executive Governance, and moreover, she's a scholar of the Maastricht Center for European Law. We really thank that she's here today. And Sabrina, when you want, please, if you can give your speech within 20 minutes or so, that would be great. Thank you.
Thank you very much for the very kind introduction already. And so, okay, you should see my slides now. Good. Well, first of all, I would like to thank Daniel and Dolores and the whole EU Law Live team for making me part of this great webinar. And also Jeff and the whole LexAtlas network for the fantastic work they have already been doing and for making me part of that as well. So thank you very much. Maybe just as a clarification, so I'm not working at the European Medicines Agency anymore. That was quite a while ago. I'm an assistant professor at Maastricht University at the moment. So I have no insider knowledge whatsoever to reveal to you today in that sense. What I'm going to talk about today in terms of vaccines and the internal market is an interest of mine that comes more from the EU administrative law side of the problem, because I'm going to talk about the composite nature of administrative procedures with regard to vaccines. What I'm going to do is I'm going to first give a little bit of a very rough tour of an introduction to EU pharmaceutical law and COVID-19 vaccines. And then I will explain a little bit what composite procedures are and how they play a role with regard to these vaccines. And then I'm going to have a look at a very specific composite procedure, and that was the inspection of an AstraZeneca plant in Italy, and some questions that raises, just to exemplify concerns I raised before with regard to composite administrative procedures. So let's start. We have already heard from Gavin a lot about Article 168, and I just wanted to relate it a little bit to the vaccination policy in the EU and pharmaceutical law. So as you have heard, first of all, Article 168 contains a mainstreaming provision that the high level of health protection needs to be ensured in all policies, and that becomes really important with regard to pharmaceuticals and vaccines. Since, of course, a lot of EU law in the area of pharmaceutical regulation is based on the internal market, then together with the public health article. So the fact that actually there can be EU harmonization of pharmaceutical law is enshrined in Article 168 in the 4th paragraph, which allows the EU to adopt measures to set high standards for the quality and safety of medicinal products as well as medical devices. However, and that should be very clear, of course, the organization of the healthcare systems is a national competence. So if we want to translate what is on this slide now to the EU vaccination policy, how that works is that in essence, the authorization of the vaccines falls within the remit of harmonized EU law, and in our case actually has been carried out on EU level also. The procurement that we will hear about of the vaccines usually would fall into the remit of the member states, but there, as we all know, and as we will hear in more detail, that there was a different situation with regard to the COVID vaccines. And then finally, the vaccination policy. So who will be like the prioritization of recipients of the vaccine and so on. That is generally also, of course, a member state policy and competence, but has been severely influenced this time also by, for example, the Commission communication on the vaccination strategy. Now, generally speaking, when we talk about pharmaceutical regulation in the EU, it should be recognized that by now, basically the whole pharmaceutical life cycle, from the idea, from the clinical research of a pharmaceutical product, including vaccines, to the authorization of it, and then the post-marketing stage and the so-called pharmacovigilance. So that is the detection of adverse reactions and the regulatory response to that. All of that by now is subject to very detailed harmonized EU legislation. The core of this EU law very much is the marketing authorization requirement. And indeed, marketing authorizations, as we have already heard from Gavin, can be obtained via different routes. There's the centralized procedure, which is available for certain innovative type of products, for example, which is the procedure we used also for the COVID-19 vaccines. That is really carried out at EU level. And then there is what we discussed in the panel before, the possibility to have national authorizations. They can remain strictly national if you market your product only in one member state, or they can actually be mutually recognized in accordance with a quite elaborate procedure. Now, what has happened with regard to the COVID vaccines? First of all, it should be established that there is no specific regulatory pathway for vaccines. They are treated like other pharmaceutical products, right? So there's no special vaccine authorization procedure. It follows the normal legislative framework for pharmaceuticals. That includes the procedural as well as kind of also the scientific requirements. There's a small exception with regard to the influenza vaccine because that is basically just adjusted every year according to the recent mutation of the influenza virus, the recent form of the influenza virus. So the COVID vaccines were centrally authorized at EU level according to pretty much the centralized marketing authorization procedure as such. So there was no direct form of a kind of emergency authorization, let's say, of a COVID vaccination. However, there were tools that speed up the process of authorization on EU level. That was that the companies were first of all given quite extensive, or had the possibility to obtain quite extensive advice by the European Medicines Agency, even in their development stages before they actually applied for the marketing authorization. The tool of the so-called rolling review was used. That means that, well, generally the European Medicines Agency would start the assessment of the scientific dossier that has to be submitted for proof of quality, safety and efficacy of the vaccine once they have the whole pack, and that can be quite extensive documentation. What they did was to basically assess the data as it became available. So once a stage 1 clinical trial, for example, was concluded, then actually the EMA already started looking into this data. There was the potential to use the so-called accelerated procedure. You can only use that once there is a full scientific dossier. And that reduces the assessment time that the EMA would spend on that dossier from 210 to 150 active days of assessment. What actually has been used and what comes maybe closest to an emergency authorization on EU level is the conditional marketing authorization that has been used for all of the 4 vaccines, if I'm not mistaken. That basically allows an authorization at a point where there is enough scientific data to actually fulfill the requirements of quality, safety, and efficacy, but some of the studies might need to be supplemented further on in the life cycle. So if you can think of the COVID vaccines, for example, we still until today are not sure, for example, for how long a vaccine will provide enough immunization. This is a study or a type of study that is still ongoing, and that will be resubmitted by the marketing authorization holders of the vaccines in order to obtain a full normal marketing authorization. The Commission decisions, because it's not the EMA that actually authorizes the vaccine, but they only give a scientific opinion, it's the Commission that takes the decision. That was issued incredibly fast for all of the 4 vaccines that have been authorized on the same day, if I'm not mistaken, actually, of the EMA opinion. There was flexibility with regard to labeling and packaging. And what we see right now is also that there was a change in the regulation on how to vary, so how to change a marketing authorization, which is important in the context of making the vaccines, for example, responsive to future mutations. Now, that was the basics, the very quick tour de table for the COVID vaccination framework. But what I want to focus on today is the composite nature of the EU's pharmaceutical procedures. Now, for those that are not familiar with that term, a composite procedure is a procedure that entails the input of administrative actors from different jurisdictions. In our case, then it's the member states and the European Union, in which the final decision can be issued by a member state or an EU authority, but is based on a procedure that really involves a lot of steps and input from various participating authorities. That very much speaks to kind of the sui generis nature of how EU administration works, because of the relationship between the member states and the EU level. And actually, it's a very prominent feature of the regulation of the market in EU law. So it's not specific to pharmaceutical law only, but it is prominent in pharmaceutical law. For example, I just said that the COVID vaccines have been authorized in accordance with the so-called centralized procedure that looks on the very first sight like very direct administration, a direct administrative procedure on EU level. You would submit as a marketing authorization applicant the application to the European Medicines Agency. The European Medicines Agency, and more specifically its main scientific committee, the CHMP, would form its opinion. The Commission, on the basis of that EMA opinion, drafts a decision on the authorization, which has to pass the comitology committee, and then the Commission can adopt that implementing decision in that case. However, that is only so if you look at the top level, so to say, if you look at it from afar. If you go more into detail, what you will find is that actually the member states play a really important part also in the centralized procedure for the authorization of COVID vaccines. This scientific committee of the EMA, the CHMP, is composed of member state representatives. Generally speaking, when you authorize a pharmaceutical product, one member state will be appointed as rapporteur, another one as co-rapporteur. They carry out the scientific assessment of the product in question, and then it is discussed in the CHMP amongst all of the other member state representatives. Now, of course, the EMA is an EU body, but still member states play an important role in this scientific assessment. Also, of course, in the comitology committee, the member states have an input. Actually, the centralized procedure is maybe less composite than the other procedures that are used in the pharmaceutical field. They would be relevant if we are thinking long-term about certain generics of vaccines that could be an option, or if we think about COVID treatments, then these procedures might become applicable. And in this mutual recognition decentralized procedure, in essence, it's one member state that carries out the scientific assessment of the product in question. That can be quite easily mutually accepted by the other member states in that procedural framework, or that might require some level of arbitration, you can almost say, in a body that's called the CMDH, which is composed of, again, representatives of the member states, but that is a body that is not part of the EU structure. If there is no agreement in that body, then there would be supranational arbitration with an opinion by the European Medicines Agency and the final decision by the Commission. So we see here, although, or in the pharmaceutical field, in the authorization procedures, they are really qualified as composite administration. Another nature, and something I want to talk about a little bit further as well later on, is the enforcement of EU pharmaceutical law. And the main tool of enforcement I want to talk about today is inspections. And there, the competence for carrying out inspections of pharmaceuticals lies with the member states. That's enshrined in Article 111 of the directive. And in essence, basically, all pharmaceutical inspections will always be carried out by national competent authorities. However, they can be carried out on the basis of a request of another member state, the Commission, or the European Medicines Agency. Yeah? So, for example, for the centrally authorized products, because there is no EU enforcement unit like there would be in food law, for example. Actually, the assessment or the inspections for centralized pharmaceutical products are carried out by the national competent authorities in question. For example, if you want to inspect a manufacturing site, it's the national competent authority of the country where the manufacturing site is located. The legal basis for inspections then is national law, which again has implemented the directive. And the EMA for centrally authorized products really carries out the coordination. So they can request inspections for centrally authorized products. Now, I couldn't go into as much elaborate detail on the composite nature of the procedures and all of the different steps and the informal actions and steps that are part of that procedure and the information exchange that is part of that procedure. But it has been a topic quite a long time amongst scholars of European administrative law and European institutional law as well, that actually what we are seeing is that the EU has a very highly integrated process of administrative procedures, relying a lot on the member states, but also with competences on EU level, and very often not in the case of separate procedural steps, but in one procedure, one administrative procedure, you will see that a lot of actors at a lot of levels are taking part in that. And that raises some concerns with regard to accountability for actions taken. The one thing is that there is very much a separate political accountability. So the European Medicines Agency and the Commission, they are of course accountable to the European Parliament, but that concerns their remit of action. Whereas then in the case of an inspection, for example, if the EMA would request an inspection, that is carried out by the national competent authority. That national competent authority would, of course, be accountable to its own national parliament. And actually, there's a bit of a gap created because the political accountability mechanisms really didn't follow the fact that we are working with these very integrated procedures. There are certain gaps also with regard to judicial accountability. Quite often what we can see is that intermediate actions, certain preparatory measures can actually fall between the cracks of judicial review, so to say. They will not be reviewable on EU level, and they will also not be reviewable on national level. That again is a problem of the separate forums of judicial accountability, because of course the national court only has jurisdiction over the actions of the national competent authority, whereas the EU courts only have jurisdiction on the EU level and the implementation of EU law, of course. And as we have already heard in the discussion with regard to Gavin's presentation, as Dolores has raised, there are many questions, for example, also with regard to non-binding actions in soft law as reviewability in front of the Court of Justice is concerned, which is basically none in these cases. Then a challenge that kind of arises from that is that, of course, there are different levels of judicial protection between the member states. So actually, an action that you challenge in Italy, you might have different standing rules than if you challenge it in Germany. So if you happen to be inspected in Germany as a pharmaceutical company, your rights might be different than those in Italy. And on EU level, what we see is, and that's a constant topic, of course, in EU law, the restrictive rules on standing for third parties with regard to the Plowman case. So if we think about the centralized marketing authorization and the authorization of COVID-19 vaccines, they can be a non-authorization decision, for example, could be challenged by the marketing authorization applicant as the addressed party of that decision. But third parties like NGOs or a competitor company will have very much difficulty to challenge a decision. Now, how can that become an issue, let's say? I would just want to give you an example of that, and that is something that I have discussed together with my colleague Mariolina Eli Antonio on EU Live in an op-ed, and that was the inspection of an AstraZeneca plant. Now, we travel back in time, although I guess we all want to forget most of what happened in the last times. But if we travel back in time to March 2021, we are kind of in the height of the debate surrounding AstraZeneca and the question whether or not they deliver in accordance with their contract with the European Union. So they had fallen behind on the promised deliveries. And we are in a situation where the export of vaccines is subject to an EU authorization. And in that context, then what happened according to the press, because this is something that we can kind of only recollect from how it has been reported by La Stampa and Politico, for example. In essence, what they report is that the Internal Market Commissioner, Thierry Breton, has, after having inspected a Dutch manufacturing site of AstraZeneca, wondered where actually all of the doses manufactured there are going. And as the reporting has it, he actually then requested the Prime Minister Draghi to carry out an inspection of a packaging plant. I think that's mainly what they did in that plant. So they packaged the vials of the AstraZeneca vaccine. That inspection has been carried out by the Italian authorities. According to reports supported by the Italian military police, they went to the AstraZeneca plant, inspected it, and discovered 29 million doses of the vaccine, which at that point in time when all of this became acute were suspected to have been headed to the UK without an export authorization. Now, there's disputes surrounding that, and I don't know better than anyone who needs to follow this in the press. But in essence, that's the context of what I want to say. Now, what was the legal basis of that inspection? As I have just said, there is a general enforcement power via the member states, and that has been implemented in Italian law with a very broad article that basically says that this national competent authority may proceed at any point and without prior warning to inspect the premises where pharmaceuticals or raw materials are manufactured. If we look into the export authorization implementing regulation, there also it says that the competent member states authorities may verify the information that is submitted by the applicant in request of that authorization request. So we have an inspection that was carried out by Italian authorities. I'm about to finish, Dolores. I see you coming on. I will wrap up. That was carried on by Italian authorities on basis of a very broad mandate and on a request. How formal or informal that request was, we don't know, by the European Commission. The procedural outcome of that inspection was not clear from the press reports. So to what extent can actually the Commission be held accountable, and what are the rights of the companies protected, or how are they protected in this situation? And this is a very good example of where we fall into the cracks of the composite procedures. Actually, the request for of the Commission to inspect is probably something that will not be reviewable under the Act of Annulment procedure due to the lack of its legal effect as such. Then there is the potential of an Italian court to ask a preliminary question, which, however, in case of a very informal request, is of course relatively unlikely and depends on the willingness of the national Italian court. For the inspection itself, also, the national Italian court is the accountability forum, but of course that then cannot review in itself the request by the Commission to inspect. With regard to political accountability, you would have the European Parliament as the main accountability forum, or the European Ombudsman, and the Italian Parliament or national accountability forums, but none of them can actually really review this integrated nature. So to sum up, and this goes back very much to a comment that was already raised with regard to kind of the technocratic decision-making and the need for democratic control of that. EU pharmaceutical law, like many policy fields in the EU, is very much characterized by its integrated nature and the composite procedures. That's an integral part of the regulatory life cycle also of the COVID vaccines. We have this composite regulatory procedures and enforcement, but actually a separation of the accountability mechanisms for that. And it has been advocated in the literature concerning pharmaceutical law, but much broader than that, actually, that there is really a heightened need for procedural cooperation of parliaments and the ombudsman. Questions of whether or not it might not make sense to have reverse preliminary questions, where actually the EU court could ask questions also to national courts, and national courts could ask questions amongst each other in procedures they face. And especially with regard to enforcement of pharmaceutical law and inspections, of course, a gap of accountability is very unfortunate due to the essential nature of the fundamental rights protection against inspections. So I will leave it at that, and I'm happy to answer questions. Thank you.
Thank you very much, Sabrina, for this terrific presentation. I'm looking forward to the discussion. But for now, well, I would like to remind you all that the chat is open for questions. In the meanwhile, we are going to look at vaccine purchase and distribution from a different angle, a complementary one, which is the one of centralized procedures, and more specifically of advanced purchase agreements. And to tackle this widely unexplored issue, we have the fortune of having with us Mikko Huttunen, who is Deputy to the Director and Legal Advisor in the Internal Market for Goods, Environment and Energy team of the European Commission's Legal Service. He coordinates the work of the team in the area of free movement of goods and litigates cases before the European Court of Justice. He holds a doctorate in law from the European University Institute in Florence, and over the past year, he has been a lawyer in the European Commission's Core Services team negotiating COVID-19 vaccines on behalf of the member states of the European Union. He's been working at the Commission for 25 years, of which the last 21 in the legal service. He has previously worked in the legal service in areas including trade, aviation law, and for a period of 6 years, he was the lead lawyer in the European Union's permanent mission to the World Trade Organization in Geneva. We're really extremely grateful that you accepted to be with us today, and not only because you are just the right person for explaining this to us, but also because it was, we know, very difficult for you to fit this in your schedule. So thank you very much. And you have the floor.
Thank you very much, and thank you for having me. I have to apologize, first of all, that I don't have a presentation, a PowerPoint presentation. I guess I'm trying to plead a certain workload over the past year or so as we're still negotiating these vaccines. And in the meantime, we have to do our day work, like I'm at the moment in Luxembourg, preparing for a hearing tomorrow. Anyway, so my presentation is going to be, if you like, very much from the trenches, from a very practical point of view as to what has happened over the past year. How have we gone about this process of negotiating COVID vaccines? And I think you are already familiar with the Commission's communication from last year on the strategy for COVID vaccines. So so I'm not going to go into detail of that, but I'd like us to kind of go back still 1 year to see a little bit what were the options available for the member states and for the member states to procure COVID vaccines in a context where, as has been certainly explained today, I assume, where public health is very much a matter for the member states and who traditionally are rather keen in keeping it like that. So essentially, what we had a year ago, or a bit more so, what options did we have? We basically had, of course, the possibility that member states would procure vaccines each by themselves, 27 procurement processes with all of those companies that might have been interested in providing vaccines or who had a project ongoing. Then there was the possibility, which was indeed initially tried, and I'll come to AstraZeneca in a moment. There was indeed a sort of an intergovernmental attempt to negotiate vaccines led by a coalition of 4 member states, Germany, France, the Netherlands, and Italy. While then, in parallel, if you like, the Commission also started its own discussions with vaccine manufacturers to see whether it might be, in fact, better that the Commission would take the lead in negotiating with the pharma industry. There was, if we go back to May, June of last year, a certain tension certainly between the Commission and member states on this very basic question as to who should be doing it. Ultimately, it was decided that it should be the Commission to do that. And I can guess, I know some of the reasons, but I can guess some of the other reasons. Fundamentally, we were just out of the first 2 to 3 months of the COVID crisis and had just seen how the internal market might be quite dramatically split, with borders being closed for essential goods and so forth. And I think at the very top level of government, there was a feeling that this should not be repeated when it comes to vaccines. We basically should not be having vaccine wars between member states, and of course, embedded in all this was also the question: what is the right legal vehicle for doing all this? Because ultimately, this is about procurement. At the national level, it would have been obviously the national procurement laws. At the international sort of intergovernmental level, it perhaps was not clear at all what rules would then be applied for the actual procurement. The Commission then proposed a path forward, which is in a sense memorialized in the communication of June of last year. But from the more legal perspective, the real key is an agreement that the Commission and the member state concluded on the basis of what is commonly called as the ESI regulation, or Emergency Support Instrument. It's Council Regulation 2016/369 as amended by Regulation 2020/521. And in this regulation, you have a provision in Article 4 that allows for procurement. It actually allows for different kinds of procurement, but one of them was particularly interesting for the exercise, and that is set out in Article 4, paragraph 5, point B, which says that the procurement can be conducted by the Commission on behalf of member states based on an agreement between the Commission and member states. So this is what we did in a matter of, frankly, a few days. We wrote an agreement that contains 7 articles and an annex to it, and which lays down the foundations of the procurement procedure that then was used and is still being used as we speak for the purpose of procuring COVID vaccines. I'll describe you very briefly the structure of this agreement. Just to clarify, it's kind of an administrative agreement between the Commission and each of the member states. There was essentially an offer that the Commission made to each and every member state whether they would want to be party to this agreement. It was then carried out through an exchange of letters. Each member state agreed to it, and off we went. So basically, there is the very foundation is that the member states mandate the Commission to procure vaccines on their behalf, in their name, on their behalf. And then very, very importantly, that this is not joint procurement in the sense of the Commission also acquiring vaccines. It's very clear, also on the basis of the legal basis, that it's only the member states who acquire the doses. They take title of those doses. The Commission is acting as a central purchasing body, essentially the negotiator of the member states for the contracts. Then the agreement provides, in its Article 3 and 4, it foresees 2 kinds of advanced purchase agreements that could be concluded. Under Article 3, we're looking at what would be called a pure options contract, where there's a right to purchase, but there's no obligation for member states to purchase any vaccines. We have, in fact, one such agreement, which is Sanofi. It has not yet been, as Sanofi is a bit delayed with its development process, that the actual purchases have not yet materialized. We actually, at the time when we were drafting this agreement, we thought that there would be more of that kind of agreements where the Commission, through EU funding, would be providing for funding for the purposes of developing the vaccine, while then the member states would, on the basis of the APA, have the option to buy vaccine doses. Now, it turned out to be that essentially because of the bargaining power set up between basically everybody in this world, almost perhaps except for the United States, and the companies, the companies required that there would be an obligation to purchase at least a certain number of doses upfront. In other words, committing legally to buy those doses already in advance of them being placed on the market. And in fact, most of our agreements are of that kind, although each and every one has also then options for further purchases. This is foreseen in Article 4. Since in a setup of that kind, you have the member states actually have an obligation to purchase vaccines. It's foreseen in the agreement that the member states can opt out from such an agreement, so that if they don't want those vaccines, if they don't like the terms and conditions of those APAs, they can say no, I'm not interested in this vaccine, and then with that vaccine manufacturer, they could perhaps then have their own agreement if they so prefer. Then we have a couple of provisions that essentially just clarifying matters. First of all, that once the agreements with the manufacturers are concluded, they're legally binding on the member states, on the participating member states, unless they have opted out. And then there is a provision that concerns the division of responsibilities between the Commission and the member states. And it's clarified that the Commission is responsible for the procurement activity itself, the liability that might come from the procurement activity itself, while the use of the vaccines is then the liabilities are for the member states, including to the extent and as the companies have ended up requiring a liability protection for against third-party claims. Then finally, there's an article which wants to, if you like, protect the integrity of the procurement procedure, then obliging the member states not to negotiate separately. To the extent that the Commission is negotiating, then it's only the Commission that negotiates, and the member states cannot negotiate separately unless, of course, they decide to opt out, in which case they can then have their own agreements with those manufacturers. There is then a longer annex to the agreement, which basically sets out the procedural elements, including how the member states are part of the joint negotiating team with the Commission, how there is a steering committee that consists of all the member states, these bodies essentially being assisting the Commission in the process. I'm not going to dwell into more detail of this agreement. It's surely publicly available and might be of interesting reading. There are still, when one looks at it, a few niggles, but which, in terms of which demonstrates that we were a bit in a rush. So, I mean, just typos that were left clean. Then the way in which the financial regulation is also an important instrument here, because the ESI regulation cross-refers to the financial regulation of the Union, and the procedure that we used there was the so-called negotiated procedure without prior publication. So in other words, we were negotiating directly with the companies. And at first there was a market research where we were literally negotiating with tens of companies, in contact with tens of companies, to see what do they have in offer. Is their project sufficiently advanced? How does their manufacturing look like? What is the kind of price range we're in? How many doses they might be able to make available, and so forth. And on the basis of this kind of market research, we then opened a formal tender procedure initially with 6 companies, later on added 2 more. These procedures have ultimately led to many agreements. In fact, we have by now 3 agreements with Pfizer-BioNTech, 2 agreements with Moderna, and the second agreement is actually just about to be amended. And then we have agreements with Sanofi, AstraZeneca, Johnson & Johnson or Janssen, and CureVac. We are still negotiating with 2 other companies, Valneva and Novavax. Of course, those negotiations are now more and more focusing on variants and the ability to purchase variant vaccines. So that's very broadly how this has happened. We put up together. We established a sort of a joint team between different services. And then we had 7 member states participating in the so-called joint negotiating team. Prior to proposing any of these agreements to the member states for signature, the Commission first approves it and then opens the opt-out process with a view to signature. We discussed all the controversial or the potential issues that there might be, and asking the member states, well, apologies, my doorbell. whether they are now ready to conclude this. Of course, the situation when we go back to last July, August, September was of the kind where the demand for these vaccines was just incredibly high, and there was a rush to conclude all these agreements. And of course, the companies were in a some of them at least were in a relatively good bargaining position, which is then reflected in some respects in particularly the early agreements. Also bearing in mind that none of them had at that time a vaccine that was proven to be efficacious. So this necessarily and safe. This necessarily required significant flexibility in those initial contracts in terms of a number of elements which have been, I suppose, sufficiently debated in press. I stopped reading the press a long time ago because most of the time they either got it wrong or it was just simply too frustrating to read all that because so politicized, particularly at national level, and then it was kind of picked up and started circulating without much of scrutiny in all member states, basically. So that's how we have gone about it. What do we have for the future? The ESI regulation is still there. We are probably, from the procurement perspective, gradually moving towards a situation where we will have to start considering more open tenders, more sort of public tenders, asking companies to submit bids on the basis of certain criteria, and that will be set out in advance. To the extent that will be necessary, we just don't know. We don't have the crystal ball, just as we didn't have the crystal ball a year ago in terms of which vaccines will be functioning. We don't have today the crystal ball to know whether and how this virus is going to mutate, what kind of vaccines will be needed in the future. We have certainly prepared ourselves in the sense that we have now contracts in place that will secure vaccines for EU member states and their citizens, their inhabitants for a year or two to come, including provisions on obtaining the variant vaccines as soon as they become available. I think I'll stop there because I'm sure I come from these vaccine trenches with knowledge that is not obviously available to outside world in the same way. So I'd be very happy to take any questions because you may have many thoughts about these, and I'd be more than happy to share those with you to the extent I can, because we're still very much in those trenches negotiating with these companies, and as I'm sure you have become aware, there are all sorts of confidentiality elements embedded in those contracts that the companies in particular are rather keen on keeping as such. Now, some of these contracts have actually leaked, and once they're out there, they're of course in a way available for any questions that there may be. So I'll stop there. Happy to elaborate on any of these elements, whether it's the AstraZeneca saga or whatever, and why did we purchase what vaccines. I can go into the scientific debates we've had with European scientists and so forth. But I think it's perhaps more interesting to hear what you might have in mind there. Thanks very much.
Thank you, Mikko. We are reaching the end of the session, but I think it's worth to sacrifice a bit the time devoted to the conclusions and to have a discussion now, because there are some questions. I would propose that Professor Gavin Barrett takes the floor now to pose these two questions he suggested on the chat, because I think he needs to leave soon, and then we'll proceed with the rest of questions.
Great, thanks very much indeed. I shouldn't be here at all, actually. I'm supposed to be at home at this stage, but the talks were so good, I just had to say to see them. So thank you to both speakers. Mikko, could I ask two questions of you before I go? First of all, I heard, and I'm not sure whether it's true or not, that the member states were something of a drag in terms of negotiating flexibility. In terms of negotiating the contracts, and that maybe a more streamlined position whereby the Commission, if you like, wasn't so dependent on them, might have facilitated getting a better deal. I don't know if that's true or not. So I just wanted your comment on that. And secondly, just the point about best efforts, rather than actually requiring the actual the execution of the contractual entitlements. Was that a mistake in retrospect?
Well, thank you for this question. Very topical, of course. The way in which member states have cooperated, acted in this whole process is, I must say, it's surprising to read about them being particularly difficult. I haven't actually. I mean, there has been a bit of a divide, that's for sure, between groups of member states that may sometimes have to do with how deep their pockets are. It might have to do with the question of, if we take the example of Pfizer-BioNTech vaccine, it has a very particular cold chain requirement, which in itself was a challenging thing for some of the member states before, obviously, anybody knew how efficacious it might be. This issue soon became a non-issue when everybody realized that this is actually a vaccine that is really great against the virus. But these vaccines had logistically very different challenges, and that certainly did reflect a little bit in the discussion. Also, price issues did reflect in the discussion. And we did have this sort of debates, but the way in which it may have been portrayed outside, that there would be big fights, I really wouldn't say so that much, because bearing in mind how politically loaded and complex and how we needed to act quickly, member states have broadly been acting in a very solidary, I would even say the spirit of real solidarity. I mean, I've never experienced anything of that kind, where the member states in a meeting within the steering committee are cheering us, are shouting "Vive l'Europe." This is not what is portrayed outside. So I'm an insider a little bit, of course, and I may be biased in that sense. So that's just my judgment on it. Of course, there were issues. I mean, there's no hiding the fact that we're looking at extremely important decisions with huge financial implications. Of course, there were tensions. Of course, there was important discussions as to how many doses would we want of a given vaccine, bearing in mind what that may bring about. Clearly, there was tension, but bearing in mind the stakes, I would say the overall atmosphere between member states was pretty good. Coming to best efforts, now we absolutely insisted on shall deliver on a given date. Trouble is you didn't have those vaccines, so the companies were saying, well, sorry, but we cannot commit to a given date. We cannot even commit to a specific timeline between authorization and the first deliveries, because the development was still so much ongoing. This is, of course, concerns the earlier contracts. As we have learned, best reasonable efforts has not been that bad in the end of the day, as the Belgian judges have finally concluded. And when we see contracts that have been essentially made available, this for the earlier contract, this seems to be the standard that all the companies were insisting on. of course, the situation looks a little different if you go to the United States, where they have certain legislation in place that allows them essentially through law impose a priority supply from manufacturing sites located in the United States, which we didn't have. Now, if we then go, and we in our sort of internal jargon, we talk about first generation, second generation, and third generation contracts already. And I'm sure at some point in time, when our so-called third generation contracts see the light, the public light, you will surely be seeing their language that has nothing to do with best reasonable efforts, but very, very, very firm commitments with very firm penalties for failure to deliver. It's a reflection of the bargaining power situation between the companies and the EU essentially as a whole. The rest of the world, I would say, unless you have the kind of legislation in place that as the Americans had. And have. Is it a mistake? Probably. I mean, for sure, we can say, had we not conceded on that point, we wouldn't have had those contracts. That is clear. It would have certainly been dragging on for a much longer time, and I think by now we would be very heavily criticized for dragging our feet for that issue. So, in a sense, it was a calculated risk we had to take. We knew that that's not the firmest of contractual commitments, but in a way we had to use then the financing tools that we had and see and essentially establish a process of partnership with the companies. Now, sometimes partnership works. Sometimes they have their little issues, as we have had with one company, but I think we're getting there even with them.
Thank you very much.
Now we have two pending questions from the chat. I think they are addressed, both of them, to Mikko, but Sabrina, feel free to answer too. The first one is whether the confidentiality clauses in the agreements could and how affect individuals who want to file for just compensation in case they have an adverse effect as a result of the vaccines. And then the other question is whether there have been any challenges on pricing, legal conditions, production, etc., concerning vaccines, which are specifically based on antitrust in Articles 101 and 102 of the treaty.
Thank you. The first question is actually a very important one from the perspective of how these negotiations went about. And just to give you some background, the United States have what they call a PrEP Act, which exempts pharmaceutical companies from any litigation except in the case of willful misconduct. So essentially what was the situation in the US was that if there is an individual who suffered side effects, the government covers. This, of course, it was very, very comfortable for the companies because they had no risk there, essentially. At the very beginning of negotiations, the pharmaceutical industry certainly insisted that we would have to change our legislation to mirror the one in the United States. And we said, absolutely no. We are not touching a iota of our product liability rules. And now this was obviously a very hard stance from us, which then led in fact to a couple of companies just walking away from the table for a little while, and explains why, at least partially explains why a couple of them, the negotiations took a little longer than they otherwise would have. The companies came back, and then we negotiated so-called indemnification clauses. What does this mean from the perspective of a patient? It means that the patient can sue the company without any limitations stemming from these agreements. Product liability rules, as they are set out in the Product Liability Directive and at national level as implemented, stay entirely intact. So if somebody, and including also the liability, the sort of patient compensation schemes that are in place in member states. It is only if then the company is found liable and has to compensate the victim that the company may then turn to the relevant member states and say, well, I have now been, a court has awarded this to a patient. So you member states, it's now your turn to pay me back. That we have then negotiated with the companies and negotiated the conditions under which that can happen. I can't go into the details of those, although I think some of the clauses have leaked. In each contract, they're slightly different. The most important element I can say at a general level is that our contracts require the manufacturer to absolutely guarantee that they comply with every possible rule that concerns the bringing to the market of a pharmaceutical product. So if they were to compromise on the way they have brought that product to the market, the member states would not be compensated, broadly speaking. So, but bottom line, the confidentiality of these agreements, the rules, the provisions in these agreements do not affect at all the rights of the patients who might be suffering side effects. When it comes to competition law, there has been, I think, one question sent to the Commission, my understanding, in terms of how this might articulate between competition law. That was not a very serious, and I can't really go into the detail of that, but it was not a very serious issue, and so therefore we haven't seen that side at all yet, at least. Let's see how things develop. What has happened is that there are challenges against the marketing authorizations granted to Moderna and Pfizer-BioNTech, and those are being litigated as we speak.
Thank you very much. I hope this answers the questions which were posed by Johan van Rentenberg, who's a Belgian practicing lawyer who's attending the session today. I think Sabrina wanted to ask something too.
Yes, I would also abuse my privilege here and ask a question to Mikko. And that is the experience of everything that you now presented in terms of the procurement of the vaccines. In how far would you say will that shape the future setup of the HERA, which, as I understand, will also have similar powers, you could say? And especially I would be interested also in the transparency of the negotiations, and if that had an effect. Thank you so much.
No, thank you for that question. It's a very topical one. Again, HERA is and again, it's in the policy making side of things. I haven't had much time to follow that, but the HERA is really coming out of this experience. We want to have something that is at least close to the BARDA in the US, and I believe that the idea is to have more permanent structures in place, so that we don't have to do it in the way we have done. We were forced to do it here because we simply didn't have any of those structures in place. So we had to improvise in a context where, in principle, member states were very, very, I mean, not only because of the treaty, but also historically very keen on keeping these kind of things to themselves. And suddenly we have a pandemic where they realize that it crosses the borders. We've got to do something together, and we've got to do something together so that this doesn't actually then have an impact on how the EU might be challenged as a construction. So clearly this experience that we've had will very much be, and I'm sure will be, influencing the future, in the sense that we need to be better prepared. We need to have structures in place that can basically start from day one and address a future event of the kind. Now, who knows? Maybe we have another 100 years without an event of this kind. One would hope so, but not so sure. So this will surely be a focal point for the foreseeable future in terms of how the EU is to respond to health crises of this kind. I think there will also be a discussion in terms of how the WHO will be used in the future, and certainly the new US administration is taking a different and more positive stance on that too. I think the second question was about the confidentiality. I mean, this is a tricky thing. We want to be far more transparent than has been the case so far. There are elements to this. There's a temporal element. The temporal element relates to the actual ongoing procurement, because if everything is made public, and we see that already to some extent with the most recent negotiations we're having, when the companies learn as to what sort of clauses are in those contracts that have been already concluded, that gives them some ideas, and that obviously makes our position a little bit more complicated. But more importantly, the companies are very, very, there may be a bit of a cultural thing as well between US companies and European companies, but they are very, very keen on keeping the clauses confidential for their own for their own reasons, because they are negotiating with other parts of the world. Now, over time, I'm sure these contracts will become, not only because they seem to be leaked, but more and more of the clauses will become known. It's a classic situation that if everything is public, it's very difficult for you to negotiate. Yet, of course, we have to be held accountable, and we want to be held accountable because this is really important public policy, and we're dealing with very, very large sums of money. We are already being investigated, of course, because by the ombudsman and who knows who. But that's right. We should be, and I'm relatively confident that that process will come to a conclusion that we have at least done all that we could. What is obvious that we would have lost money because nobody knew which of these vaccines will be functioning. We would have invested in vaccines that ultimately failed. We might be purchasing too many of those vaccines. Who knows? Our aim is certainly, and this is a very important element in those contracts, is that if we have excess supply, those will be then either donated or resold to countries in need. In fact, there's a process already going to that effect. Many of these vaccines that are, because at the moment, some member states are taking decisions so that they don't want to continue using certain vaccines. And these are immediately being shifted over to developing countries. And it's very important for us that the whole policy is that we are not safe unless everybody's safe. These viruses don't respect traditional borders.
Is there any other question? In that case, we are already out of time, so we'll be stopping here. I just want to devote one final minute to honestly thank you all in behalf of both ELL Live and the LexAtlas COVID-19 network for being present here, for participating in this session, and for your invaluable inputs, which will help us all to keep on thinking, researching, and practicing the law of COVID-19 vaccines. We hope to be in touch with you very shortly concerning the publication of today's presentations, which will hopefully take place right after the summer break. In the meantime, we wish you all a very nice and safe holiday, and of course, a full and prompt vaccination. Thank you very much.
Thank you.